Okay, good morning, everyone. The time being 10:03, we'll get started on the exec session for SB 513. And I want to start off with Representative Spilsbury. Representative Spilsbury and Representative Ames have been working on this to see if we need an amendment or what we need to do with this. We'll start with Representative Spilsbury and then go to Representative Ames.
Thank you, Mr. Chairman. I believe that the bill as introduced by Senator Gannon was adequate in its own way, and that there are two different issues that have become confused that, unless we're told otherwise this morning by our visitors, I think we can strip them back away. The first issue is who exactly, which entity requires an exemption from the licensing requirements. And the bill that, as it was introduced, was that a non-member individual, which is to say an outside auctioneer who's not a member of this organization having the auction, can conduct the auction without a license for that organization. I think that's straightforward. When you look at the existing statute that this is proposing to amend, that's RSA 311B13, that statute is within the statute that authorizes licensing of auctioneers. And it says very simply that a member of a charitable organization can conduct an auction without a license. So this is adding to that. That existing provision identifies the entities, and this leads us to the second question. The existing statute, 311B13, says that a member individual of a charitable organization, educational, religious, or other nonprofit. And Senator Gannon's uses the exact same phrase: charitable, educational, religious, or other nonprofit organization. In the existing statute, as with this bill, there's no effort to further define charitable, educational, religious, or nonprofit organization. They are broadly used generic terms, and I think that's because the intention of the existing statute was to be sweeping and to allow for all of them. So I don't think there was any need to define those terms, and the existing statute has operated without objection, even though those terms are not defined. So the second element of confusion that's entered our discussion is that the Senate amended their own bill, and we've received it with this phrase in line 4, if eligible under RSA 721(2)(b). So the Senate's amendment introduced a cross-reference to a statute that defines nonprofit organizations. And when it came to us, we then started to say, wait a minute, what about fraternal organizations? What about religious groups? What about churches? So if you were to wade back in and examine what did Representative Janigian's amendment do, what did Representative Fellow's amendment propose to do, etc., they are trying to address these two forms of confusion. And it turns out, I believe, that when you realize that the broad phrasing charitable, education, religious, or other nonprofit is identical to the existing statute that this is being added to and hasn't required definition, we could very simply, my opinion, amend the Senate bill to remove the phrase if eligible under RSA 721(2)(b) and just let the terms charitable, educational, religious, or other nonprofit organization stand on their own. They're plain language. They can be interpreted without having to be defined as terms of art. Okay? And then this leaves us with the original intent that the subject of this whole thing is non-member individuals. You can hire an outsider to conduct your auction without his needing a license for that purpose. If everyone agrees, if our guests concur, I would say we could get a very simple amendment drawn this morning to remove the Senate amendment and go back to the original as introduced bill.
Thank you, and thank you for your work on this over the past few days. Representative Ames, would you like to add to that?
Well, first, thank you to Representative Spilsbury. I agree with what he said. It's really, if you step back from this, this is a, should be a non-controversial amendment that responds to a gap in the allowance for non-licensed people to conduct auctions. And it does so without disturbing the protections that are already in the statute for situations that currently are allowed for auctioneering by non-licensed people in the situation where they too are members of the charity or the charity where the auction is being held. So this expands that and has all the safeguards in it. And it shouldn't be that difficult. I think one thing that's hampered our dealing with this and our is that we really had no substantive testimony that gave us context to work on this bill, and this certainly is not our field of expertise. We're sort of dealing with a subject that has to do with licensure that usually doesn't come this way. So we've had to wrestle with that too. But putting all that aside, it's a simple matter, and I agree that we should use the language that's already in the statute for that narrower group that's already authorized to provide auctioneering services in a very narrow context, and to use that language, charitable, educational, religious, or other nonprofit organization, to define the arena within which the unlicensed individual may function, and fix the language and go forward. And the simple fix is to go back to the original bill as filed, or to amend this bill as it came to us and write in that language. And to me, that would be sufficient. So I agree really entirely with what was proposed.
Thank you, Representative Ames. Thank you both for working on this over the past few days diligently. I appreciate it. Yes.
Just to, I had noted that we didn't have any substantive testimony, but we did have a letter from Senator Gannon that got submerged underneath all the other stuff that comes in and didn't come to our attention until we started working on it this weekend. And it's a good explanation of the context and the background of regulation for auctioneering services that exists. So I just want to point that out. I think you all have received that.
Yes, thank you. Yes, everyone should have received that in their email. It's roughly a 2-page letter from Senator Gannon. So with that, I would just like to first mention that on very short notice, we have, can't read the last name correctly, Ailey Byers, who is one of the original proponents of this, and also Michael Haley from the DOJ Trust Division here to just kind of hear if they think that what's just been proposed to go back to the original bill, not amended. So first I'm going to invite up Ailey, if you could come up and tell us your thoughts on that. She'll introduce herself.
Hi, so I'm Ailey Byers. I worked with Senator Gannon on this bill. I am a licensed auctioneer working here in the state of New Hampshire. And to give a slight background, the impetus for creating this bill is that if you, which you guys wouldn't need to do, if you were to look through all the rules and regulations of what an auctioneering license requires and what it is designed to do, it's designed to protect the seller of items as we traditionally think of auctions. So it's a matter of how the funds are transferred from the buyer to the seller, the timeline that happens in, how the advertising happens, the care, custody, and control of the items from when you take them from the seller to when they're delivered to the buyer, the records that are kept for the sale, and if there's any question about the items or the property with the buyer, the funds are put into escrow and held in a place until the resolution is taken care of. If you are working with a nonprofit and doing a nonprofit fundraising event, for instance, Easy Thought, you're going to the animal shelter at your hometown and someone is providing services to raise funds for that, the person providing the auctioneering services never takes control of any item, never is in any care, custody, and control of any of the funds, never is in control of any of the advertising, and never really has knowledge or control of where the items are coming from, and never has records about where the items are going to. So the laws we have in place don't really apply in any way, shape, or form to someone providing auctioneering services to a nonprofit. Hence the idea of removing those individuals from being covered under requiring an auctioneering license, because the laws don't really apply to what they're actually providing for services. The creation of the bill was incredibly simplistic to mimic, as you said, the current description of what it was. It's basically nonprofits. All of us in our head probably think 501c3s and 6. It's basically what it meant to be. So we just copied the current RSA regulations. I understand potentially why they wanted to clarify what New Hampshire views as a nonprofit, but as you said, it's kind of redundant because it's already what the original RSA and rules and regulations state in 100 through 500, and that's never been clarified. And again, the current rules say if you're a member of the organization, you wouldn't have to have a license, but there is a growing body of professionals like myself who travel around the country and work solely for nonprofits. And therefore, we are paid on a flat fee, most of us are paid on a flat fee basis to provide those services. And we would not be members of the organization. They would choose us for our abilities and to execute what they need taken care of at their event to raise the most amount of funds.
Thank you. Yes, Representative Hillary.
To go to the law, what would prevent you from advising someone how to run an auction and letting someone in the charity run it?
Absolutely nothing. I do that with some groups. I go in and just do the consulting and I don't actually execute the auction.
Okay. So you wouldn't be covered
Follow
by
up?
follow up then. So this law as proposed wouldn't really affect you, would it?
No, this law is for those individuals that show up at the actual event and execute a live auction component, or what would potentially also be covered under the auctioneering law of an appeal, where it's a request for cash from people in the organization. So if the nonprofit is not doing an auction component, then it wouldn't matter. And if you were just consulting with a nonprofit, it wouldn't affect you either. So there are fundraising consultants that are just hired for their expertise, and then someone else performs the actions at the event.
Representative Spilsbury.
Yes, thank you very much. I think that was a good, clear description, shows how simple this really is. I would just point out that all of the amendments, all of the confusion have related exclusively to the first sentence. Sentences, the second through the sixth, essentially echo the stipulations why it is that we aren't requiring a license, because the auctioneer is not handling the seller's goods, et cetera.
Thank you, Representative Almy.
Yes, I just want to get clear on the language here on does not allow someone who is not an auctioneer anywhere to do the auction.
So, under the current law, if a nonprofit was to hire an individual, i.e., pay a person to perform the auction at their event, and they are non-licensed, one, that individual would be subject to the New Hampshire Board of Auctioneers disciplinary actions, and two, the nonprofit could potentially be subject to some sort of problem because they were using a non-licensed person. It also technically, according to the RSAs and rules and regulations, the nonprofit should be, as the rules and regulations state, putting the licensure number, if they were to hire an auctioneer licensed individual, put all that information on their advertising, which none of them do because the auctioneer is not the important part of the event. It's the raising funds for the nonprofit. So it's also creating or removing some technical barriers that the nonprofits should be doing.
Follow up?
Yes. If I am a member of a nonprofit that has never done an auction before,
Right.
and I read this language within the context of the rest of the auctioneering, am I going to understand that without a license for that organization means that I don't need, that the person who's going to be doing the auctioneering doesn't have to have a license as an auctioneer?
Correct. So
But is that clear from that language? Because it isn't to me.
I would have a hard time answering that because I've been licensed in the state for 12 years, so I've been in this for so long. But I think for a decent amount of nonprofits in the state of New Hampshire, they are aware of the fact that either it has to be a member of their organization, that has to be someone that's licensed, or they could have a person who is non-licensed and non-member, but they could not receive any compensation, including a meal. They could not receive anything of value to perform the auction, is what it currently is, a system we live under.
Representative Ames?
Yeah, first, I just wanted to point out that there are consequences right in this statute for for performing auctioneering services outside of the licensure arrangement that's allowed by the set out by this statute, or the exception to it for the member of a charitable organization. And one of those consequences is any person violating the provisions of this RSA and not exempt, that's the membership exemption, shall be guilty of a misdemeanor.
Yep.
So it's,
Thank you.
definitely a consequence. And then I would say that you just have to bear in mind that this is a narrow exception, that the member who is allowed to do an auction is subject to limitations. I'm looking at the existing statute that's already in this statute, that this individual must not take physical or legal possession of goods being sold, must not collect or transmit payment for transactions. There are a bunch of provisions. I won't go through them all. So it's tightly contained. That's what I want to say.
Yes, exactly. Yes, Representative Schamberg.
Thank you, Mr. Chairman. Thank you for taking this question. Does the suggestion by Representative Spilsbury, in which line is that, Representative Spilsbury, for?
Pardon me. To remove the citation in line 4, if eligible under RSA 721-2B.
Would that address what you have presented to us?
Yes, as a person that helped draft the original version, we intentionally copied the original language, so I feel it's very okay.
All right. Yes, Representative Almy.
Yeah, we have one of the amendments that was suggested by people here before on reads, and I'll take out the RSA language. Non-member individuals without an auctioneering license may be hired by any charitable, educational, religious, or other nonprofit organization for auctioneering services for charity auctions for that organization. Is that what we're talking about? Because
Yes,
that's a lot clearer for an amateur.
That's what we're talking
yes, that is what we're talking about.
Yeah. I think that I would defer to Representative Ames and Representative Spilsbury on that because they've analyzed this, both being lawyers. We'll also hear from Michael Haley from the Trust Division. Representative Spilsbury, do you want to?
Just a reaction, Representative Almy. I think that the language in Representative Fellows' amendment also works, but it also includes that reference to RSA 721 that has to be removed. So why not just stick with the Senate bill?
I don't understand.
Microphone.
Because I don't understand it, and my Democratic Party many years ago now, so it's past statute of limitations, got someone who was not a licensed auctioneer to do an auction for us. We never did one again. She was excellent, but I read this over and over again, and I couldn't figure out which organization they didn't have to have a license from, the original.
Representative Fellows.
Yes, I'd just like to respond to that and say that the sentence is poorly structured, but it's a copy of the exception that's right above that, that's for the members. So this language wasn't invented for this bill. It was copied from the two, this is 2A. It's just a slightly amended version of 2. So while my thought was when I began, that the sentence could be better written, so could the sentence that's in section 2. And then you're going down the rabbit hole, because then people are going to say, why are they not worded the same? Does it mean something different? And this situation exists all throughout our statutes, that things are not really worded very well. But I certainly want to hear from the Attorney General's office, but focusing just on what statutes should be referenced in line 4, I think is what we should just focus on right now and not try to rewrite the sentence.
I think that's why the proposal is to remove that statute reference there and go back to the original bill. Any more questions for Haley? Okay. Seeing none, thank you very much, and thank you for coming on such short notice. Literally, she was asked yesterday afternoon.
Thank you.
Now I'll invite Michael Haley up.
Thank you, Mr. Chair and honorable committee members. My name is Michael Haley. I am the Director of Charitable Trusts at the Department of Justice. When this bill was originally proposed, we didn't have any particular objection to it when we first reached out when we saw the Senate amendment, and our concern there was just that it might create some confusion about which groups were eligible. We don't take a position on the bill, and my specific concern was that the existing statute referenced religious organizations, it referenced other nonprofits, and many of those are not charities as defined in the statute that was referenced. So I thought it just might create some confusion about who was eligible. Under our statute, you're a charity if you are a 501c3, or if you hold yourself out to be a charity, or if you engage in fundraising for a charitable purpose from the public. And that's unfortunately different from what the IRS defines to be a charity. It's different than what the Lottery Commission defines to be a charity. It's different than what the municipal groups define to be a charity. So introducing a fifth definition of charity seemed like it just might create a lot of confusion. I don't think that there's any confusion with the original wording. And all I wanted to be here today was to make sure that the groups that this bill was permitting to engage in this activity were the groups that the legislature was intending. So obviously there's a broad range of nonprofits that are not charities. The IRS recognizes more than 20, almost 30 different types of nonprofit organizations, and only one of those is charities. So membership organizations, the C6s that were just mentioned, the veterans groups, labor unions, agricultural groups, some credit unions. There's a lot of different types of nonprofits. So as worded, this bill would allow any of them to engage in an auction. And if that's what the committee is looking to do, I wouldn't take any position on that.
Thank you. So do you agree that if we take out the reference to the RSA and go back to the original unamended Senate bill, the intent is still there?
That would not be confusing as far as I'm concerned, to simply remove that statutory reference.
Okay, thank you. Representative Platt?
You took the question out of my mouth.
Okay. Representative Fellows?
Thank you. So I understand the original bill. What you're saying included charities, but it also included more than what we call charities. Can you help me with line 1? Because it says charity auctions by nonprofits. Yeah.
Thank you for the question. So yes, they're charity auctions by nonprofit corporations. So nonprofit corporations, at least in New Hampshire, are any organization that's organized under Chapter 292. That's the New Hampshire statute that allows the formation of nonprofits. And you can form a nonprofit for charitable purposes, but you can form a nonprofit for many other different purposes as well. That are not included. So, for example, C4s, which are the social welfare organizations, C6s, membership organizations, things like the Elks Club, those are all nonprofits, but they're not charities. And this, because of the way this bill is worded, any other nonprofit organization, any of those types of organizations would be allowed to would be covered under this statute, even if they weren't a charity as defined in 721.
Follow up.
Follow up?
So I'm asking you, what word do you think we should have in line 1? And I'm not entirely sure about for the statutes. I'm concerned that word charity is in there, because some of these things are not charities. And we could just say for nonprofit corporations, except that I know that the churches are not nonprofit organizations. So do you understand the question?
Yes, thank you for clarifying. Our churches are nonprofits, but they are not charities under the state statute. I believe, and I'm not an expert in this, but I believe that the line 1 would not ultimately show up in the chapter in the law as it amends the RSAs. Is that correct?
Follow up?
So, and it's also in the title of the. Should we change the title of the bill? Well, that's important, I think, though.
So as far as which organizations are eligible to conduct these auctions, I don't think that the word charity auction introduces any confusion into which organizations are eligible, because the language below is pretty clear about who would be allowed to do this.
Yes, Representative Almy.
Thank you. This language, line 1 and the title, are created by the drafters. It is exceedingly hard to get the drafters to change something that is totally erroneous. And this one is just slightly erroneous.
I'm sorry. What, Representative Almy, what was your concern?
No, it isn't a concern. It's that this is not a concern because it's not, we would have to go to Alaconis and get him to talk to the drafter and get him to change his language. It's not legal language of the bill. It is the description by OLS.
Okay. Representative Ames?
Oh, no.
Okay, Representative Ulrich.
Thank you. You mentioned those entities that are organized under 292. There are some entities that do charitable work that aren't organized under 292 because they're organized under the IRS. And there's a section, I forget the chapter and verse, that says that if you're federally organized, you don't have to be state organized. That's the state law as well. That's in the banking code.
Sure. So, so 292, RSA Chapter 292 is the statute that creates the entity, and the IRS grants tax exempt status to existing entities. So most nonprofits are formed as a corporation or as another type of entity. You can be formed as some of the associations are not formed as corporations. I was unfortunately shorthanding that a little bit, but there are organizations that are unincorporated associations. They're not formed under 292, but they have an IRS tax exempt status.
So, follow up, sir. Would we need to put in or having an IRS tax exempt status in there someplace? Or would we be then requiring everyone to become organized even though their charter says they can't become organized? I'm thinking of the fraternal organizations.
Yeah, I think, thank you for the question. That might create more confusion because churches are not they don't often get a tax exempt status from the IRS. They simply can operate without it. So that could make it, there are some churches do seek tax exempt status and receive it. Some choose not to. And it's up to the church whether to seek it. So that could create some confusion about who's eligible.
You follow up on that?
Follow up?
You're aware that every organization is now required to file a 1099. Or excuse me, an EIN. They have to obtain an EIN number and file a tax return every year. Every organization. Whether they're religious or not.
So federal tax law is not my specialty. It's my understanding that there are churches who do not seek a tax exemption from the IRS, and so if that would be the basis for granting this or for allowing this this auctioning to occur, that it might inadvertently exclude certain churches that the legislature was intending to allow. Simply removing the reference to RSA 721, I think would be pretty clear about who's eligible because it encompasses charitable, educational, religious, or other nonprofit organizations.
Thank you. Representative Spilsbury.
So again, to attempt to simplify and clarify in the way that I began, the existing statute that we're amending will sound very familiar. 311B13(2) says any resident member of a charitable, educational, religious, or other nonprofit organization within the state may conduct a charity auction without a license for that organization. So really all we're trying to do is say in addition to a resident member, also a non-member. Okay, that's all we're trying to do. So any departure from that same phrasing just introduces confusion because it begs the question, why did the legislature mean something different by choosing different words? So let's not go there. I'm going to use the word wide and narrow in the same sentence here. I think Representative Ames accurately said this has a relatively narrow purpose. But the phrasing in terms of the organizations, charitable, educational, religious, or other nonprofit, is broad. It's intended to be sweeping. So I think all of the concerns regarding the definition of church or fraternal organizations and Knights of Columbus and so on are included in this broad phrase. Any effort to further amend it actually works against that purpose. And I think that's why the introduction of the Senate amendment became confusing. The Senate Amendment 721 2B, that's the statute that defines charitable organization. So inclusion of that phrase just seemed to reverse the idea of being broad and inclusive and go to narrow it. Okay, so I believe Mr. Haley has said everything that I agreed with and confirms what I'm saying. If we just go back to the original as introduced language, all of this confusion disappears.
Thank you for the question. Yes, that's my, as far as I am concerned, removing the if eligible under RSA 721 2B language removes confusion for me and does not make it unclear to me which organizations would be eligible to participate.
Thank you. I'm just going to take one more question. I think we keep circling around and coming back to the same conclusion at this point. Yes, Representative Elberger.
Thank you, Mr. Chairman. I am more confused now than I was at the beginning. I have a real problem with using the term charity because I'm not sure what we're talking about with charity. If educational institutions or any other institution comes along, let's say a for-profit school that comes along and says we are having a charity auction, and because it says educational institution can be included in here, to me that the term charity is a contradiction. So at this point, barring a last minute epiphany, I'll be voting against this. Thank you.
Representative Ames.
Just a comment on that. The only organizations that could host an auction by a non-licensed person under this proposed change are nonprofits by the text of this bill. Non-member individuals hired by a charitable, educational, religious, or other nonprofit organization.
Okay, I want to wrap it up. Representative Plett, you have something to...
Yes, I'm going to ask Representative Spilsbury if we struck the word charity in line 1, and then below on line 5 struck charity, would affect anything.
Representative Plett, I believe that that is not part of this bill. That's just a reference. Is that...
It is part of this bill.
Well, I can answer both those.
Okay.
The caption charity auctions, I think, is just using a term of phrase in common usage, right?
Yeah.
And that's not the statute. What lines 1 and 2 are saying is insert the next paragraph.
Right.
So the statute is lines 3 to 10 here.
Right. So, Representative Elberger, to that point, does that make it easier for you to accept this, where that's just reference to where this is going to be placed and not, okay. All right. Representative Ames, and then we will end.
I probably shouldn't open my mouth since we seem to be just about there. But in line 5, the charity auctions concept does reemerge, and I just want to point that out and say that I think it would be construed by anyone who needed to construe this as the word being used in its sort of definitional sense, common definitional sense, as a charity. It's not to make more money for the organization that's hosting the auction, but it's to promote a charity or charitable purpose that can be defined. It's some general concept, but I think it needs to be in there. It's, you don't want to allow, I think the drafters of this didn't have in mind allowing auctions to be conducted by unlicensed auctioneers that would raise money for the business side of, say, a nonprofit hospital. You know, I think that's, I see that my friend down there has some.
I'm also reluctant to open my mouth, but I agree completely with what Representative Ames just said, and I would point out that in the existing law, the exact same reference is made, may conduct a charity auction without a license.
Yeah, there you go.
Thank you.
Thank you.
All right. Thank you, Mr. Haley. Appreciate your time.
Thank you.
And thank you also for coming on very short notice as well. At this point, we need, based on the discussion, we need an amendment. And I think the consensus is to remove on line 4 if eligible under RSA 721 2B. While Jen, is that something that you can have drafted? While that's being done, I'm going to suspend, I don't know what the appropriate word is, recess the exec session and recess the exec session and come back after, when the bill comes in, we'll go into the public hearings. Representative Fellows.
Yeah, I would just like to ask if it won't hold up the process, if we could work on the title, the act title, and change it to auctioneer license exemption for nonprofits, because this is really, we're talking about auctioneer licenses. So that would, just to make that more clear.
I would rather not change the title.
We can't change the title without going through Alaconis
Well-
and him going to the drafter and the drafter agreeing to.
Okay.
I
Yes.
think that the drafter, if we ask for it, as I said, if it doesn't hold it up,
Well,
we could pursue that.
it would hold it up. Okay, so I am now going to recess the exec session on SB 513. And once that amendment comes through, we will reopen the exec session once whatever public hearing we're on is finished. Okay, so that is recessed. Thank you, Mr. Haley, and thank you, Ailey, for being here. Appreciate it. Do you have a gavel? Okay. Okay, I'm going to open the public hearing on SB 472. Representative Lang, we'll now recognize you. Senator Lang.
Thank you, Mr.
Sorry
Chair.
about
Thank you,
that.
members of the committee. It's great to be back in Ways and Means again. Senator Tim Lang, Representative District 2. I'm sure this feels like deja vu all over again on this topic. This bill before you is our historic horse racing and moratorium bill. This time we hold the moratorium at 7 years. Extending it out for a period of 7 years to give time for the industry to mature and to see what we want to do. It also gives time for the Charitable Gaming Commission to do its work and make recommendations to the committee after reviewing the data and what's happening within the industry. The bill is pretty straightforward again. We add the people who have already applied for licenses in a narrow window of time to licensees. We then extend the moratorium out 7 years. New wrinkle to this bill is we've added municipal hosts to be able to act in essence as a charity, but only if there are dates available. So the charity gets first bid on the dates. If there are dates still available after all the charities have been serviced, it would allow a municipality to be able to hold up to 10 days. And the revenue, the 35% revenue that would normally go to a charity would go to the municipality to offset any local costs. In addition to that, it also restricts the transfer of licenses, and I think it's just a restatement of law. As you're all well aware, you can't sell a gaming license in New Hampshire. You can sell the business, but not a license in and of itself outside of the business. So this restates that and makes it clear that that is the exact law. Happy to take questions.
Thank you. Representative Ullery.
Thank you, Senator Lang. The question is, New York put similar restrictions on their taxi medallions. Immediately, the value of the medallions skyrocketed. Won't the same thing happen with the value of businesses that are engaged in here, and thus restrict trade and make this type of activity less competitive and more expensive for the consumer?
So again, that's why it's a 7-year sunset clause. It allows us to evaluate what's going on in the industry. And if we choose to do nothing, the moratorium will expire and it'll become a full-blown free market again. However, at this point, because it's a pretty significant change in how gaming operates, this new form of gaming in HHR, we think we need a slight pause to see what's going on to make sure the data supports any other changes we make.
Follow up?
And you're assuming that lottery is going to keep this data?
I'm sorry, say that question again?
You're assuming that lottery is going to maintain a database that would provide the information regarding the cost of licenses and the competitiveness of the business?
So again, so the Charitable Gaming Commission that we established last year, which is meeting now, is one of the topics we're reviewing is exactly that. We get the data on what the market can support, what the revenue looks like. We just hired, I think the Executive Council last week hired the people we're bringing in, Spectrum Gaming, the experts we're bringing in who are going to be doing modeling for New Hampshire as compared to other states and what that looks like. But again, we don't have that data. We will have that data after that analysis is done.
Thank you, sir.
Representative Southworth.
Thank you for taking my question. Could you provide a little more context about the availability of the dates? Because it seems like, at least in some facilities, they get used up very quickly, and much more competitive. So I'm just wondering, for example, if there often will even be anything available from municipalities.
In some there will, and some they won't.
Yeah.
So to your point, in the larger charitable gaming facilities, those dates probably wouldn't be available. In the smaller ones, they tend to be. I tell you that in the bill, when we had this conversation, we had a charity come forward in the Senate Ways and Means hearing. Win Arrow from Laconia. And they talked about there was availability right away for dates through the Belmont Gaming Casino. And they went in, they did the application, they were immediately given a date because there were dates available. So in some cases, there will be dates available. Some cases, there won't be.
So really, it's really variable.
Correct.
Thank you.
Representative Alming.
Thank you. Following up on that one, I think this is totally impossible. You are saying in line 8 that it is required that they annually operate a minimum of 7, but not more than 10 game dates for the benefit of town or city. Required. And then you go on to say all of the times when they don't want to do it, but you've said notwithstanding any provision of law. And I was under the impression that just about nothing except the North Country, possibly Lebanon at this point, because there's this tiny little place that's still operating while they're waiting to build the Taj Mahal on our very trafficked road, has any game dates. They've got long waiting lists. So how does this work, except for maybe in Berlin and possibly Laconia?
again, it's where it was available. Understanding that not every charitable gaming facility is going to have dates. I will also tell you that the topic you're talking about relative to charities and gaming operators, again, is under provision and purview of the Charitable Gaming Commission. They're looking at how those charities are selected, how days are selected. Again, that commission is looking at a lot of topics relative to charitable gaming and how, we've to a certain extent, we've kind of patched this law as we've gone along and not taken a big picture look. And so I'll just say to you again, the same as I said to Representative Southworth, it's going to be ad hoc. It's going to be sometimes there will be, sometimes there won't be. There could be a charity that was allotted games that all of a sudden on a Tuesday went out of business. And now there's a hole in the schedule and they get allot that time to a town. I don't know all the conditions and circumstances that a town would be able to get dates, other than to say that if there's a hole in the schedule, they would be able to plug it with the town to be able to use that as a source. And the Gaming Commission is looking at how charities are selected and what that looks like.
Representative Almy.
This is just a follow-up. I do have another question later. On one, you say required, notwithstanding any provision of law to the contrary. And two, there's nothing in here about what if the town doesn't want any of this and didn't want it in the first place, like Littleton and like Lebanon, but has been forced to take it.
Thank you. That hadn't come up in any of the hearings I talked about. A town was going to refuse revenue. I hadn't heard that conversation anywhere else. I suppose if you want to amend it to allow an opt out of the town saying we don't want your money, you can do that.
Representative Platt.
Describe to me the horribles that might happen if we eliminate the moratorium.
So again, I wouldn't presume to, you mean to make it free market as it is right now? Again, I wouldn't presume to make that guess. The Charitable Gaming Commission is working on that. The concern was, again, a proliferation. Right now, I don't know the most current number. The last time I heard about 1,800 machines in New Hampshire so far for HHR. The question is what the proliferation would look like if we had an unrestricted market. Again, that's part of the Charitable Gaming's review with Spectrum Gaming, the experts in the field, to make that determination for us before we start making changes.
Representative Fellows.
Thank you. Can you remind me of when the change was made to say that it could be 2 charities on the same date? Was that just last year? Or
So that was
can you
again part of
explain?
the original HHR bill, which I can't remember. I think it was Representative Doucette's bill or Abrami. I can't remember which it was that did that bill that allowed for 2 charities in a given night, one for Games of Chance and one for the HHR.
Representative Almy, did you have a question?
Oh, yes, I did have another question. I hadn't realized that one of them would only be the machines and one of them would only be the tables. But I did want to just ask again why we bother to put in transfer or sale of license prohibited when the businesses are already there. There are at least 4 in the group that Lebanon is in that are owned by the same outside of the state companies working through a developer in Manchester. And there, I think, are the 2 in Nashua are also owned by the same person. Yes. And probably with people from outside the state controlling that one. So it's really hard to think that this is any kind of a free market. And I gather that the Lottery Commission does not think that that a business can be kept from merging with another in any way at any time.
So thank you for the question again. if I understand that this is a restatement of law that says that the license itself cannot be sold outside the business. So I can't, remember, I form a business, I apply for a charitable gaming license, and then I apply for an HHR license, right? Those two licenses are assets of the business. They can't be sold separately from the business. That's just a restatement of law that makes it clear that that's what we intend, is that the license itself, I can't sell the HHR license outside of selling my whole business, and I can't sell my charitable gaming license outside of selling my whole business.
Could I just ask,
Yes.
On-
Follow up.
does this, I don't remember the law being any different before this, so does this change, whatever it was, actually create any further impediment to us being all owned by Las Vegas?
So again, Representative Almy, to my point, you can always sell a business, and I don't think we want to restrict the sale of businesses in the state of New Hampshire because they're just LLCs, and you would have to, good luck trying to figure that out. This says you can't sell the license in and of itself. So I can sell my business, and if my business has assets, the assets go with that business.
Does this change, what is the change in the existing language?
Again, I think it takes what's currently in rules and puts it into law.
Oh,
We've
okay.
always had the idea that you could never sell a license, and this just puts it into statute that clarifies and restates you cannot sell your license. It makes it absolutely clear.
Representative Doucette.
That was
Oh, okay. Yes, Representative Elberger.
Thank you, Mr. Chairman. Thank you for taking my question. Licensed charities, yeah, I know, I can do this, you have trouble. Licensed charities are, I assume, charities that are under 501c, but the following numbers are not restricted.
Well, actually, they are, and that's in the charitable gaming statute.
Okay.
Like, so there are provisions of what qualifies and what doesn't, and that's in the gaming statute.
Now, is that a similar list to the list that we were talking about in the last bill?
I'm not sure. I don't think so because, again, that was talking more about not-for-profits for charitable purposes and not necessarily charitable operations. So I will say, just to take a diversion, that section about that RSA in that bill was added at Senator Rosenwald's request. She wanted it in the bill, and I just agreed to it. So you strike it. I have no problem with that. It wasn't in the original bill.
Follow up.
Thank you. I'm curious as to why we have charities given preference over municipalities.
Again, that was a negotiated agreement in the Senate with our Democratic colleagues and our Republican colleagues. The charities didn't want to see lost revenue. So again, if we forced or if we said that municipalities were treated exactly the same, but there was a shall in there saying every year they get 7 to 10 days, then there's a charity gets displaced, and that caused some consternation in our group in the Senate Ways and Means. So we wanted to make sure that no charities got displaced by the municipality.
One more, very
Follow
quick.
up.
I'm not sure this is a question, but more of a statement. If we look at a charity as an organization that provides for the public good without a financial benefit for shareholders, I don't see a distinction between a charity and a municipality.
I agree.
Thank you.
Representative Fellows.
Thank you. Last year, we had some questions about the fairness of how the charities were selected and the fact that when they get in the door, they get to stay there usually, and it's the operators of the establishment that select who they are. What is the status of that? Do we have a study commission looking at that, or I'm sorry. Are there any bills related to that?
So again, the Charitable Gaming Commission is looking at that to make recommendations on any future possible legislation if it's necessary.
Representative Ames.
Just further on the ownership and the transfer question that Representative Almy was asking, I think would you agree that it would be possible for the state to set a rule in legislation that even the Charitable Gaming Commission might recommend that would preclude sort of monopolization of all the operating historic horse racing charitable gaming sites by one entity. You could limit ownership. You could spread out the ownership. And we could figure out a way to do that that would not preclude a owner of a particular one of these enterprises from selling it, but they just couldn't sell it to another casino operator in the state, so that you would avoid this monopolization issue that I think Representative Almy is concerned about.
So I guess my answer is yes. Having served 4 terms in the House, 3 terms in the House and 1 in the Senate, the legislature can do anything it wants,
That's
including allowing short-tailed monkeys for pets.
All right, Representative Spilsbury.
Thank you, Mr.
Find a
Chair.
way.
Senator Lang, perhaps you can clarify for us what was the effect of the amendment adopted by the Senate relative to its original bill?
Thank you. So it was the addition of the municipal hosts was the big part. I think we also, my original bill was a 4-year, and we negotiated to a 7-year to get everybody on board.
Okay, I wondered about that, looking at the fiscal note where it refers to 4 years. So it was originally introduced as 2028 and it was amended to 2031.
Correct.
Thank you.
Representative Almy.
Thank you. Why do you not want to take the position that was sent to you from the House, which we thought would have a better chance of getting through the governor?
I'm assuming you're talking about Senate Bill 112, and I'm not ready to discuss that right now.
Why do you think that the governor is more likely to take this one?
So again, you're talking about Senate Bill 112, and I'm not ready to discuss that right now.
No, I'm talking about this one.
I'm sorry. So your question is, why
would
think
the governor sign this one when he's refused to sign?
I wouldn't
other?
presume to speak with the governor, but I had had conversations with the governor, and it seems to be he's in a favorable position to this bill.
Thank you, Senator. Seeing no more questions. Okay, next up, I have Rick Newman.
Thank you, Mr. Chairman. My name is Rick Newman. I'm representing the New Hampshire Charitable Gaming Operators Association. We are in support of Senate Bill 472. I wanted to start by trying to answer a couple of questions that have been asked. Section 3, which is the section that prohibits the sale of the license, is in fact simply a restatement of the current law. In the current law, that sentence exists in Roman 2. This bill has redrafted Roman 2, so it removed that sentence from Roman 2, and it gives it its own paragraph. So it's a new paragraph 8. But that sentence is in and has been in current law for many years. It is pretty well settled across the country, and I think probably across the world, that in the gaming business, you can't sell a license. So I can buy an entity that may be eligible for a license, but then I have to go and prove my own worth, be vetted by the licensing authority, which in this case is the Lottery Commission. So I wanted to address that. In our view, the most important part of this bill is Section 7, which is the section that extends the moratorium date out to 2031. And as you folks, I'm sure, are well aware, this is at least the 4th time you've seen a bill to extend that limitation or moratorium, whatever you want to call it. You've passed Senate Bill 51, which was vetoed by the governor. You've passed Senate Bill 112, which would have made the moratorium indefinite. That's in the Senate, has yet to be acted on. You passed Representative Doucette's bill, which again, I think, I forget the number, but it also made the moratorium indefinite. And here we are addressing that issue again. In my view, from what I understand, this is the bill that has a chance of becoming law. So if we're going to, otherwise what happens in July 1 of 24, and the question was asked, what would be the downside to that? Well, in July 1 of 2024, unlimited entities could apply for historic horse racing licenses. And at the moment, you might, while we have 14 gaming facilities, and I believe 10 of them have historic horse racing, we believe as game operators that that's enough, and the market can't really take much more than that. This bill is going to allow up to 5 other potential new facilities. But we don't think anybody really wants to see a state with 50 or 100 locations, and I believe that's a very real possibility. So we think extending the moratorium is very important. And I just want to address the host community sections 5 and 6, where that addresses where the money goes. Where the money goes is not our concern, that's yours. We are happy to have some of it go to a host community if that is if it works out. And as Senator Lang said, it wouldn't probably happen in every location because many places have a waiting list. But those that don't could use this provision to get money for the host community. I would point out that given the fact that this bill will increase by some number, up to 5, the number of facilities that will likely be operating if this bill passes, just keep in mind that for each facility that opens, that's 730 new charity gaming dates that become available. So if a host community got 10 days from each and every room, that's only 140 gaming dates. And if one new entity opens, you're going to add 730 to the inventory. So I don't see any, really diminishing charities revenue here. With that, I'll take questions if you have it.
Representative Platt.
I'm confused. See if I find the right line now. Under page 2, line 7, notwithstanding any provision or law to the contrary, game operator employees licensed under RSA 287D4 required to annually operate a minimum of 7, but not more than 10 game dates for the benefit of town or city, etc. That's required. And yet I hear from Senator Lang that this is after charities, if there's dates available. I'm confused. How does it, what does this required mean? Do they have to bump charities off to do it?
Well, I believe I understand what you're saying, Representative, and keep in mind, we didn't participate in the drafting of this language. This isn't our thing. But I do believe that Section 6 addresses that and says if there are charities available, the municipality does not get any of those days.
Representative Doucette.
Thank you, Mr. Chairman. Thank you for taking my question, Mr. Newman. Just for reference, if these applicants that were in the queue right now were to secure the licenses, you said it would add somewhere in the neighborhood of about 700 plus charities to the pool that would be eligible.
730 game dates, yes.
Right, the dates. Do you have any idea as to, with the present operators, how many charities are in the wait lists, or how many charities are in the queue to, and this is in relation to the Charitable Gaming Commission too, it's kind of information that would be interesting specific to this municipality component.
My latest information, excuse me, my latest information is that I believe all of the rooms have a waiting list for charities. I'm not aware of any that have open dates.
Follow up?
Okay, thank you. And you don't, a charity doesn't have to be specific to that community, to that specific community. Say Salem Little League Baseball can have and I just happen to know this, have dates in Manchester.
Correct.
Right. So any qualified charity can be in any charitable gaming room.
That's correct. And I would just point out that that was really made possible by changes you folks made a few years ago when you eliminated the requirement that a charity representative had to be at the facility. That opened it up to so that a place in a charity located in Berlin could have game dates in Manchester.
Follow up?
More of a statement because I know it's not the operator's position, but we as a legislature went through a series of years where we were trying to legalize casino gaming in New Hampshire, and my town, Salem, was a focus of that. To me, reading this, and specifically the required language and on, to me, charitable gaming services charities that need service delivery to our communities, and we're all aware of that. This is a slippery slope, writing in town, and I understand the benefit to the towns and municipalities, but this legislature chose the charity model to go forward. And I don't want to, in any way, shape, or form, negate service delivery to the many eligible charities that do great work for our constituents under the guise of a little sugar cube for a town and municipality for hosting a charitable gaming room. So I just think we have a charitable gaming model. It needs to stay with the charities.
If I could just address that briefly. Excuse me. I'm not going to say I disagree with anything that you said, Representative Doucette, but I will say this. I am greatly concerned about this issue of the moratorium. And, as we know, as the legislative process proceeds and goes forward, if we have to get into a situation where there's a conference committee or something like that, I'm concerned about the moratorium. I think the urgency of extending the moratorium supersedes any other concerns, particularly since, and I can follow up with my members to confirm this, but I believe I can represent without fear of contradiction to you that at least as of today, every room has a waiting list for charities.
Representative Ulrich.
Representing the charities, you're aware of what happens in other states.
Yes.
Are you aware of any other jurisdictions where this type of legislation exists?
I'm not. We really are unique in New Hampshire. In every other of the 38 jurisdictions, I believe, in the country that offer casino gambling, it's all commercial gambling. That doesn't mean there isn't bingo or other types of charity gaming that take place in those other states. There certainly are. But our casino gambling in New Hampshire is focused on charity gaming, and there is no other state that does anything like that.
Thank you.
Okay, thank you. Seeing no more questions, thank you.
Thank you, Mr. Chairman.
Next, I have Alyssa Margolin.
Thank you, Chairman Janigian, members of the committee. For the record, my name is Alyssa Margolin. I'm here representing the New Hampshire Center for Nonprofits. We're the statewide association of New Hampshire's nonprofit sector. We do not have a position on the moratorium. I'm here to speak and raise concerns about shifting revenue from the charitable sector to the host community, and also issues around how charities are selected. So again, we don't have a position on the moratorium. And as you've just had a good exchange, we have gaming in New Hampshire to the extent that we license a sponsoring charity And those charities include C3, C4, C7, C8, C10, C19s, according to our gaming statutes. So we license those entities that sponsor operators who provide these activities for the public. And that has brought in really essential revenue to the nonprofit sector. And in New Hampshire, we rely on the nonprofit sector more than other states, providing essential services to our communities. This, of course, lowers tax burdens overall because we have fewer government contracts and we're able to identify philanthropic and other sources of revenue for the charitable sector. I do want to thank Chairman Lang and the members of his committee when we expressed concerns about the proposal to shift dates that were currently available to the charities to the host community, that we were opening the door to a slippery slope. As we know, in New Hampshire, there are many needs. Don't doubt that there are impacts and costs that happen at the municipal level, and we do recognize that all the effort and infrastructure that goes into making these activities that happen, that generate this revenue. And his committee did provide a thoughtful amendment that essentially gives the right of first refusal, or however you want to look at it, that says if you have a wait list and you have charities in line, that you wouldn't provide those dates to host communities. We asked this committee to consider if there may be another source that makes more sense to address some of the needs, because really, although the revenue generated for a charity is meaningful for their bottom line. So, for example, one of our members provides shelter beds for domestic violence. Boys and Girls Clubs provide extra after-school activities and can provide capacity for that. But whether or not this is really going to provide for the law enforcement needs or whatever the local needs are, we're not sure that that revenue here really makes sense. But we do appreciate the effort and the understanding, and that we were heard in the Senate. But I do want to say that for us, on page 2, section 6, lines essentially 25 through 27, this was extra language that was added to the amendment that says, shall not apply if the facility licensee institutes a policy forbidding the facility from hosting a specific charity or specific type of charity due to prior conflicts with charity management or employees. We're not aware of any history of kind of problematic relationships between the sponsoring charity and the management. We're not really sure what the enforcement mechanism would be for this. We are concerned about issues around mission bias and other things that could come into play. So ask that you consider striking that if you decide to keep the amendment. With that really concludes our testimony and our view of this proposal. I'm happy to take any questions. Thank you.
Thank you. No? Any question? Yes, Representative Elberger.
Thank you, Mr. Chairman. Thank you for taking my question. One of the things you pointed out is that New Hampshire is heavily dependent on charitable organizations to provide services, and that cities and towns are not able to. If there were funding for cities and towns to provide the services that charities are picking up, how would you then feel about giving municipalities the same access to those charitable dates?
My understanding is that this proposal would not translate into a nonprofit grant program at the municipal level or enhanced services for vulnerable populations or other things. But I mean, again, our nonprofits are kind of local partners everywhere. New Hampshire Center for Nonprofits spends a lot of time teaching good management and stewardship and best practices. And obviously, nonprofit sector is open more to public scrutiny of revenue and spending. And so we don't want to keep municipalities from raising the revenue needed to host gaming in their community. We just don't think that gaming days from the charities is the way to do it. But, you know, we do understand that overall an expansion of gaming could be an expansion of revenue days for charities. And it is a complex issue. And so we understand that, you know, there are compromises needed and give and take. But in this case, we don't feel like we are really solving municipal needs. And we're potentially opening up a slippery slope,
Follow up.
pulling money away from charities.
Follow up.
Follow up. Thank you. My question is, if municipalities were given the funding that they needed, which might include some funding through charitable organizations that is currently limited to charitable organizations through the casinos, would the need for charitable organizations to pick up those services, which municipalities may not be able to afford because some of their revenue is being lost and, quite frankly, not being provided by the state, would you be looking at this differently? And your comment about transparency in terms, municipalities are probably the most monitored. But I'm wondering if municipalities were getting some of the funding that's now being moved into charitable organizations and were actually able to provide the services that belong to the municipalities to provide.
So
How would you feel?
So I think I understand, Representative Elberger. Are you saying if more revenue was provided to host municipalities, would that translate into more services for the public good, lessening the need for the charitable sector? Is that your question? So that is not our experience. For example, pandemic-related resources that came to many municipalities did not translate into the municipalities taking on delivering those services. And in limited cases where that happened, they have pulled back. So for example, in the city of Manchester right now, you know, the incoming mayor, who's very dedicated to addressing the issues around homelessness, has pulled back on municipal support for the shelter, saying that this needs to be run by the nonprofit community. So, I mean, we're, again, it's always in partnership, and there's county resources, there are municipal resources and federal resources that flow through Title I communities that go to the charitable sector. But in general, I don't think that this would this would not supplant the public good that the charitable sector is doing, but I appreciate the thought and the question.
I had a question over here for Representative Elmy and then Representative Platt.
Yes. Have you thought of the fact that there is such a huge profit that we are getting large numbers of outside of New Hampshire takeovers going on that the model that was used could be manipulated instead to use part of that profit for municipalities instead of taking it from the charities?
Was that a question or more rhetorical ones, Representative? Okay.
All right, and that may be something we can talk about in a work session as well. Yes, Representative Leapley. Oh, I'm sorry. I already told Representative Platt and then Representative Leapley.
Thank you. This may be an obvious question, but charities must like the moratoriums too, because the ones who get the dates get better revenue than if there were 50 or 100.
Again, the Center for Nonprofits doesn't have a position on the moratorium. There isn't, I don't think, any competitive benefit to it either way. In fact, you know, having more gaming dates would make more revenue available. I do, just for the education of all of us. Overall, you know, revenue has gone up. The legislature has allowed, you know, wage levels and to increase. And so wagers to increase rather. So, however, the percentage that's going to the charitable sector has decreased significantly. So while the revenue in the space has grown and the overall dollar amount to the sector has grown, charities now take 10% less of the revenue, and that's likely to continue. because of the increase in HHR and just the profitability of the activity.
Representative Leapley.
Thank you, Mr. Chair. Are you aware of any negative impacts of gambling on host communities?
I can't speak for the from the perspective of the municipal association or any adverse impacts to what local municipalities are dealing with. Thank you.
Thank you.
Follow up.
Thank you. I too am concerned about the fact that the percentage that's going to charities is going down. So I think that's something we need to keep in mind. I think we also need to take a step back and make sure we're looking at the big picture of what gambling is supposed to be doing in our state, like why we allow this in the first place and why we are supposed to oversee it. So I think your point about the charities is well taken, that it's supposed to be going there, and we know that a much bigger percentage is going to the game operators, many of whom are outside of New Hampshire. And so this could be a siphon increasingly of money leaving New Hampshire instead of enriching nonprofits, which it was designed to do. So I think we need to think about the big picture of this. I also am saddened about I come from...
Representative, is there a question there? Do you have a question for her?
Yes, I
okay.
do have a question. Is it okay if I ask it?
Please ask the question.
I'm concerned about your comments about Manchester. I wonder if you feel that the partnerships with the cities are declining, because it seems to me that the philosophy of this is we don't have to raise taxes. We can provide funds to charities. They'll provide the public services that used to be provided by the state or the city. And so therefore we won't have to raise taxes. Do you feel that your relationship with the cities is declining because of this concept of the cities don't have any money to provide public services that is for the charities to do? And so we, the city, as you cited in Manchester, aren't going to do that work because we don't have the money. It's not our job. It's the charity's job. Do you feel like that has changed recently?
I mean, overall, I can't really cite examples of a declining relationship. If the pandemic has taught us anything about the charitable sector, is that nonprofits are essential and that they are incredibly nimble. And I think that our most productive community-oriented nonprofits have managed to work with every administration from every party in many different fiscal challenges, highs and lows. And for the most part, I do think it's a very solid foundation. My point was simply responding to Representative Elberger's, if I thought that more revenue headed towards municipalities would supplant the need for the charitable sector, was no. But generally, I don't feel that there's any kind of relational decline between our where we have our municipal sector, we have our nonprofit sector, we have our private sector. And when they're all working together, I think it's good outcomes for Granite Staters. Thank you.
Thank you.
Thank you. All right. Thank you. Thank you very much.
Thank you.
All right. That's all I have for pink cards. Is there anyone else who'd like to testify on SB 472? Yes.
Still morning. Good morning, Mr. Chairman and members of the committee. For the record, my name is Catherine Heck from the New Hampshire Municipal Association, and I did not prepare testimony, but I did want to make sure that we express that we are neutral on this bill. And while that might seem a bit surprising, as we do come to you regularly looking for state aid and partnerships with the state on a number of issues, in this particular case, we do not take positions on bills that could potentially pit municipality against municipality, where some currently might have gaming and others might not have that option. This would be a legislative decision that we will not be weighing in on as to whether or not you allow cities and towns to have some portion of the charitable gaming. I will say that we do enjoy our 234 cities and towns very, very healthy and important relationships with our nonprofits who provide services, a huge range of services statewide to our residents. And our municipalities do enjoy working with our nonprofits to fill those holes that the government cannot fill. So we do find our nonprofit sector to be critical to our residents. And I just didn't want to think that there was, if there's some individual tensions going on or in some area, that is not something that we're getting a lot of feedback on, as we know that our members really do work with their nonprofit partners and they are really critical in our communities, as they do respond quickly and nimbly and flexibly to things that government might not be able to do. So if you have any questions, I'm happy to take them. I just wanted our neutral position on the record.
Thank you, Representative Platt.
Because I don't have a pink card in front of me, I'm going to ask you to spell your last name.
Oh, yes, sir. Heck, H-E-C-K, like what the heck?
H-E-C-K. Heck.
sir.
Okay.
And I will get you a pink card, sir.
Thank you. Yes, Representative Leapley.
Thank you, Mr. Chair. Thanks for taking my question. So I understand that you don't want to weigh in on something where it might be competitive between different municipalities because of their relationship with gaming. I'm wondering if the association is aware, or is municipalities have expressed any concerns about gaming, that it's been a negative impact or it cost them money that they've needed to invest in, maybe gaming addiction has increased or anything like that. Thank you.
So I have not heard of anything around gaming addiction specifically. I do know that with any business that brings in visitors, any business at all, we do see an increase in perhaps our public services like police, fire, for that, for example. And I do know the Senate was trying to address that influx into a community around gaming in their amendment. I will say that a charity that I'm involved in locally in my little community was able to get a space after 2 years. It's our Meeting House Restoration Committee for our town. And we got on the charitable gaming list in Laconia, I believe, and we live by Peterborough and Greenfield, so far away. And we got $15,000 from our 2-week stint. So again, I think that depending on the facility, the amount of time, I can't speak to the financial, what each town would receive, because that is a question that has been asked of us, and I can't speak to that because I think it depends on the receipts of that casino in that time period. So I think it really is very dependent, as I know other communities have received $60,000 for their charity in that same period at a different location.
Representative Platt.
Yes, as you say, there may be some increased police and fire and so on. What is the property tax revenue for gaming establishments compared to any other commercial property?
Well, it's assessed certainly the same way as any other property. We have to be fair, reasonable, and proportionate. So it's assessed the same way as any other commercial space. And again, I'm not picking on our gaming facilities and saying that they do create or don't create. There's many industries that bring an influx of people in because they're places that visitors would like to come and see, which is positive for our communities as well.
Thank you, Representative Fellows.
Thank you. Does your organization have a position on municipalities' ability to say yes or no to having a casino in their community? And because I think we have a bill related to that, but I don't think I'm not sure the status of that.
So just generally, I won't speak about other legislation in this hearing, but we always defer to the position of local control and having the ability to opt in and being able to plan and zone accordingly so that it's can be successful for everybody involved. So the local option is always our deferred preference.
Follow up?
So they don't have that ability right now.
I will have to get back to you. I believe that local zoning and there are certain considerations, but I will have to get back to you with a more detailed answer.
Thank you. Seeing no more questions, thank you very much.
Thank you very much for your time.
Okay. I will now close the public hearing on
Mr. Chairman,
Oh,
before
yes.
you close,
Yeah.
I have a question for lottery.
Okay. Can we invite Lottery up?
Good morning, John Conforti, Chief Compliance Officer for the New Hampshire Lottery Commission. Last name is Conforti, and I will get a pink card in. Happy to answer any questions.
Thank you, Mr. Chairman. Thank you for taking this question. It says a total of 5 entities. I'm reading the methodology on the back of the financial note. It speaks about the total of 5 entities applied for a game operator. And then your last page, the Lottery Commission states it cannot assess the final impact of this because it is unclear how many of the 5 additional applicants will be found suitable for charitable gaming and subsequently seek a license to offer HHR. Is there a theoretical, mathematical way for you to just give estimates?
So there isn't really. So the all we can tell you is that with regard to the language as it sits right now, that opened that second window from January 1 to October 18th of 2023, that there are 5 entities that fit within that window. They're in various states within their application status, licensing status, and we can't speak about that. So each one will be vetted. And so we can't really address today whether 0 through 5 of those will actually be licensed at the end of that process.
Yeah. Representative Almy?
Thank you. This is for the chair.
Yes.
I assume we'll be planning for a work session.
Yes.
And it would be helpful, at least for me, to be really clear about if there are waiting lists for every place. Because it seems to me if there are waiting lists for every place, it does really affect parts of the bill. That means there'll be nothing for municipalities and maybe nothing for any new charities. And I think that really puts this bill in a different context if we already have these waiting lists. So I'd appreciate that. Thank you.
Okay. Representative Almy?
Is there, well, we are apparently not allowed to know anything about how much profit there is in this business. I just wanted your take on that.
So Representative Almy, we do very extensive revenue reporting on how much revenue is taken in from each casino for each activity. And obviously how much goes to each charity and how much goes to the state. And that is all posted on our website. So there's a tremendous amount of visibility into the economics. Certainly, we don't have all of the overhead costs that are associated with operating. We do a review during licensing to make sure that the finances of the applicant or the licensee are sustainable. But certainly I think that there is visibility into the revenue generation out of these facilities. And I think given some other information that certainly the study committee has done, they've gotten some testimony on some of the costs that go into operation of the facility.
So
Any
could I
follow-up?
just get that clear on, we can't know the gross, but we can know the net after they've taken all of their expenses, including outside the state.
The only thing that we don't have complete visibility into is their everyday operating costs or overhead. So we certainly do understand some of the elements of that. For example, we're aware as an industry that an HHR machine, if it's being leased that can cost 20% of the gross gaming revenue around that number. It can be a little more, a little less, depending on the specific game. Obviously, there's labor costs, there's electric costs, those types of things. That's not something that the state collects on a regular basis because it doesn't have an impact on either the charity's revenue or the state's revenue. So in terms of, I think what your question is asking, in terms of their net profitability, we don't have complete insight into all overhead costs in these facilities. But certainly I would say that there's a lot of information available about the revenue that flows through these facilities.
Representative Fellows.
Thank you. I'm interested in the money that's available from take one casino. So the money that's available to them probably is divided into two parts, because one charity during a certain night, one charity is getting money from the slot machines and the other one is getting money from the table games. And I know that not all the casinos have the slot machines. So I'm just interested in the disparity. So if we have a municipality and a charity saving on one night, it matters which pot you're going to get the money from. And anything you can share about that?
Yes, Representative Fellows, thank you for the question, because that was, I just want to clarify something. That was divided in terms of one entity got HHR, one entity got table games. That actually was sunset, and now it is an even split between all revenues. So when two charities come in to a facility, Charity A and Charity B end up both splitting the HHR and GOC revenue equally. With respect to, and just one other fine point, just for your understanding, in facilities, and there's only a few at this point that operate without HHR machines, they do not have to operate with two charities. They only have to operate with one, and they choose to usually only operate with one. So there is not that issue of dividing up in those facilities.
Okay. Thank you. Actually, I've got one question. So Representative Southworth asked if we can find out if there's waiting lists for all charities. Is that something that you can get an answer for?
So, Mr. Chairman, I know Mr. Newman indicated that we are, on behalf of the study committee, getting information from charities, and we took a survey of charities within the state. I think we have 300 or 400 respondents. So we should have some data on what charity experience is in terms of getting onto wait lists or getting game dates. So certainly we should have that, I think, in advance of a work session.
Okay. Thank you. Thank you very much. Okay, with that, I'm going to close the public hearing on SB 472.
Recognize me first on 597, please.
Okay. Okay, what are we on? 597. All right, so here are these. All right, who's introducing it? Lang. Where's 597? Okay, we will open the public hearing on SB 597 and recognize Senator Lang.
Thank you, Mr. Chairman. On behalf of Senator Abart, I want to introduce Senate Bill 597 relative to Lucky 7 ticket dispensary devices. This bill is pretty straightforward. Under current law, any machine we have that's done in a social club or a Lucky 7 machine has to be able to print paper tickets. However, across the country, that is no longer the standard, and it's becoming harder and harder for these organizations to be able to get Lucky 7 tickets. So we just do away with the requirement or even the option that the machine must be able to print a paper ticket. That's the whole bill.
Thank you. Any questions? Representative Platt?
No question, but I got handed a signature list, request for removal or requirement for pull tab printers for electric Lucky 7 devices. I won't read the entire language, but essentially is support of the bill. And by quick count, it was 54 game operators supporting the bill.
Thank you.
Thank you. Any questions for Representative Elmy?
Yeah, just one. The reason I always opposed this was that it slowed down the game so that it wasn't a slot machine. How much faster is it without this?
Put that with your other.
Again, I don't have an answer to that direct question. Again, the answer in the Senate Ways and Means Committee, when this bill was heard, one of the key components was the fact that the machine's becoming harder to find without a paper, because if you can display it on the screen, having that option to print is A, rarely taken, and B, the machines are getting harder to find.
Yeah.
Excuse me, Mr. Chair.
Yes.
Was this introduced another day? I wasn't given a copy of this today.
597. Yes, we got it on a different day.
Week ago.
Okay.
There may be copies on the table. There's probably copies on the table over there. Does anyone else have question? Representative Elmy, did you have a follow-up? Okay.
I would like
All right.
to hear from Valerie King. She looked like she understood the question.
All right. Thank you, Senator Lang. Valerie King, if you would come up to the desk. Did you have an answer to that question?
Yeah, could I just restate it? Are you going to be looking at these new machines and how close they are to slot machines or to the HRM machines? Thank you.
So good morning. My name is Valerie King with New Hampshire Lottery. One of your questions was regard to how fast it would, if not having paper would speed it up. I believe that our rules, it would be based on our rules, and I believe they require that that there's at least a 3 to 5 second delay between each, before you can hit the button again. So having no paper won't change that. As far as the difference between a Lucky 7 ticket dispenser and HHR and slot machines, it's a Lucky 7 is based on a defined deal. There's only so many winners and losers in a deal, which is different than HHR, which is based on a parimutuel wager, or slot machines, which is based on a random number generator. So while they all have video displays, the internal of how those wins or losses are determined are different.
Thank you. Okay. Next, I have Rick Newman.
Thank you, Mr. Chairman. My name is Rick Newman. I'm representing Grover Gaming, which is a manufacturer of Lucky 7 machines that operate in New Hampshire. I'll be very brief. I wanted to point out to the committee that there was a time when the printing of a ticket was required by state law in these electronic Lucky 7 dispensers. You folks made that optional a few years back. I can tell you that one facility, for instance, that I'm aware of that had about 50 of these devices would literally throw away 8, 9, 10 big green garbage bags of tickets every day when they were required to be printed, because customers, the machine printed it, but the customer never looked at the ticket because the display is on the screen. I can also tell you that since you've made it optional, there hasn't been a roll of paper changed in any machine that I'm aware of in the entire state. Customers are not taking the option. So you might say, well, why do we care then about it? And the issue is simply one of ease of operation. The fact that a printer has to be connected can sometimes cause the machine to malfunction, or the printer has to be addressed, and then it shuts the machine down, and it's really for nothing because people just don't print the ticket anymore. So I think the evolution of these machines is at a point where we've proven that the printing of a ticket is not necessary. We'd ask you to support the bill.
Thank you. Yes, Representative Fellows.
Thank you. I was under the impression from testimony I heard, I think last year, that these tickets were sometimes sold at campgrounds. And are they using video machines at campgrounds?
Lucky 7 tickets come in two forms. One is electronic, which is what this bill addresses. The other is a break open, typical ticket you used to see before machines existed. I would assume if campgrounds are selling them, they would be using the paper break open ticket. I'm not aware of any facility like that that has the electronic dispenser devices.
Okay. Follow up?
So this eliminates the paper option.
Eliminates the paper option only in the electronic dispensing
Oh, okay.
device.
Okay.
Okay, the paper ticket itself is still very
thank
much
you.
alive and well.
Okay, great. Thank you very much.
Thank you, Mr. Chairman.
Okay. The last pink ticket I have is Ashley Choromanis. That's correct? Wow.
Thank you very much. That was perfect. Good morning, everybody. Good morning, Mr. Chairman, members of the committee. My name is Ashley Choromanis. I represent Grover Gaming in the state of New Hampshire. And in 2021, the regulation that required that the electronic machines print a representation of the outcome of every ticket played on an electronic device was amended. And the requirement that the printed representation of the outcome of that ticket played was adjusted from being every time a ticket was played on the electronic device to optional for the player to print a ticket if they so choose. And since that adjustment was made, virtually no player chooses to print that piece of paper, which is something that I had presented to the committee. We have an agreement, not an agreement. We have some documentation that states that our fraternal and veteran charity partners do not have any players that print those options out. So when they were required to print after every ticket played, we were changing the very large rolls of paper that Mr. Newman spoke of multiple times a week and in some cases per month. But the issue with this is that millions of very small pull tabs that represented wins or losses on these devices were just being thrown out, and they had been doing that for years. Since the change, we have not replaced a single roll of paper in any active device in the field, and many of these devices have been in some of these organizations for years. Since the electronic Lucky 7 still have the requirement that the printed ticket be optional for the player, this can lead to problems with the machines themselves, because if a printer that creates this ticket malfunctions in any way, it puts that machine out of operation until it's fixed. So until a problem is resolved, that machine cannot be played, which does not bring in revenue for those charitable organizations. All plays on any electronic device are electronically recorded, so the paper representations are not necessarily needed for any kind of security reason. Our machines specifically also store 200 screenshots of the last 200 tickets that were played, so there is a visual representation on the screen of the last 200 plays. The requirement to have the electronic pull tab machines print this ticket has no benefit to our charitable partnerships, those organizations, and it provides a disservice whenever those printers are causing the machine to be out of operation. So I would like to add that of the 6 states that our company represents similar gaming in. New Hampshire is the only state that requires this particular printing option be available.
Thank you.
Questions?
Thank you. Yes.
Thank you, Mr.
Representative.
Chair, and thanks for taking my question. So on average, how many tickets does the average player pull?
That's not necessarily a question that can be answered. You'll have a player that sits down for 20 minutes and might play through, 40 electronic plays. You might have a player that sits down for 3 hours and plays through 1,000. The fact of the matter is having the printing still have to be an option if that printer that is in the base of the cabinet malfunctions for any reason, especially if a player is in the middle of play. Not that it happens that often, but it can. It puts that machine out of operation. So the player's not able to cash or pull their ticket, collect their ticket from their redemption ticket from the machine until that machine is functional again.
Follow up?
Follow up?
So if a player wanted a paper ticket, is a printer available to hook up quickly, or is that not an option?
The printers are always available. So if a player wanted to print out the ticket, they do have right now currently the option to just play the ticket and then request that the machine print out that paper slip. But because that is the requirement, that that printer has to be available for the machine to operate, if it does not operate for whatever reason, it puts that machine out of operation. So because the printer has to be functioning on that device, it's always available to the player, but the players never use it.
Last follow-up.
Follow up?
So if Jupiter and Mars align and there's a solar eclipse. Thank you.
All right. I think.
I'm in the dark about that one.
Thank you very much. Thank you for your testimony.
Thank you.
All right. Is there anyone else who'd like to testify on SB 597? Seeing none, I'll close the public hearing on SB 597. Okay. We have one more public hearing. But before I do that, I want to jump back and reopen the exec session, which I believe should be fairly quick, on SB 513. Open that back up. We have an amendment being passed out. So the amendment being passed out removes that one reference to the RSA that we talked about previously. Does anybody have any question? Looks pretty straightforward. Representative Platt.
I move to adopt Senate Bill 513, about to pass.
Second. All right, second, Representative Southworth. Schemberg, yeah. I just want to recognize Representative Southworth once in a while. Discussion?
I'm going to hear about the amendment. We'll discuss the amended bill.
You need to introduce the amendment.
All right, I'll introduce the amendment. I move the adoption of amendment number 2024-1453H.
Second, Mr. Chairman.
Would you like to speak to the amendment?
As soon as I write it down. Yes, thanks to the brilliant work of our two attorneys on the committee, we have struck language referring to a section of statute that just confused everybody. So now it's clear that any charitable organization, no matter what type, can engage in this service, and it was already in law that they didn't have to be licensed. Now it makes clear that the person they hire, the auctioneer, also doesn't need a license for this purpose.
Representative Spilsbury, I should have recognized you, given the work you've done on
Well,
this. I apologize.
Nothing to add, except I appreciate the good working relationship with my colleague, Representative Ames.
Thank you. Representative Ames
And I gave you credit.
concurs. Okay. Seeing no more questions, the clerk will call the roll.
Sorry, 11451. Okay. I shall now do so. This is on the Amendment 1453H for Senate Bill 513. And I'll start with Representative Doucette,
Yes.
Representative Ullery,
Yes.
Representative Ammon,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Potatek, Potusek, is not here. Representative Almy,
Yes.
Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton. I'm not here. Representative Elberger,
Yes.
Representative Leapley,
Yes.
Representative Smith. Not here. The chair.
Yes.
So the vote is 17-0, 3 not voting.
Okay. We'll now move on to the bill as amended. Do I have a motion from Representative Spilsbury?
Thank you, Mr. Chair. I move OTPA on 513.
Do I have a second?
Second.
Now you guys said second at the same time, so now it's Representative Southworth seconds it. Representative Spilsbury, would you like to speak to your motion?
Enough said. Thank you.
All right. Seeing no more discussion, the clerk will call the roll as soon as he's ready.
All right, yes, Representative Doucette,
Yes.
Representative Ullery,
Yes.
Representative Ammon,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Almy,
Yes.
Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Not here.
not here. Yeah, I knocked that down. So Representative Elberger,
Yes.
Representative Leapley,
Yes.
the chair.
Yes.
The vote is 17-0, 3 not voting.
The vote being 17-0, do I have any objections to consent? Seeing none, this will be placed on consent. And I'll close the exec session on SB 513. I just want to thank Representative Spilsbury and Representative Ames once again for doing a lot of work this weekend so that we were able to pull this off and get this done. Thank you. Okay, now we're on our last order of business. I'm going to open the public hearing on SB 585. And once again, I'll recognize Senator Lang.
Thank you, Mr. Chair. In case you forgot, I am Senator Lang. I serve as a senator from Lakes Region District 2. I'm here to present Senate Bill 585. 585 is a pretty straightforward bill. Currently, when a restaurant is behind on its rooms and meals tax, or meals and rentals tax, I guess it's called now, that tax, if it's owned by an LLC, if the entity, the restaurant is owned by an LLC, DRA can apply a lien, a personal lien on everyone's personal property who's a member of that LLC. However, if that same restaurant is owned by a corporation and you have equity investors, the only people that can be applied to the private property lien are the operating, the president of the corporation as well, unless there has been an asset transfer. And if there's an asset transfer recorded by the corporation, anybody who got, any stockholder who got assets is also liable for the rooms and meals tax. So the goal of this bill is to treat LLCs similar to our corporations. If you have a passive investor, which is not uncommon in New Hampshire for a restaurant, they have no role in how the restaurant's run. They were asked to put up some money to help open up a restaurant, so they put up the money. Their goal is that in 3-5 years they get their money back with some interest, but they have no operational responsibilities within the restaurant in and of itself. The goal is not to have that private LLC passive investor be responsible and have their personal house put a lien up on for it. So they're treated similar to a corporation as a passive investor, an equity investor in a corporation in a restaurant. That's the whole bill in a nutshell. Again, it's to reduce liens of private investors in LLC that are passive in nature. Again, provided there was no asset transfer and they're not responsible for the operation, so they're not the managing partner, they're not the chef or the manager of the restaurant itself. They could not be held personally liable for their personal property. I will say that it requires DRA to do a little more work, but I would hope if you're going to put a lien on a piece of private property, you would do the work to make sure you're putting a lien on the right person's property rather than just everybody.
Thank you. Questions? Representative Ullery? Yeah? Oh, Representative Almy.
I'm not Ullery. No, and you are me. I wanted to understand how you define management. You have restaurants that are owned at 51% interest of the restaurant is owned owns 5 different restaurants. Are they considered the person that owns most of it but isn't necessarily the manager of each restaurant? Is it the guy that he hired to be the manager in the restaurant the manager, or is the guy that owns the majority of the shares in the LLC?
So again, if they're responsible for the management of the LLC officer, or there's been an asset transfer, they would be liable.
So he had somebody who owns 5 different restaurants, or I know one that owns more than that, at least one. But he leaves the management to them and just checks the books every now and then or something, or just takes the checks. He has no responsibility.
again, just being a member of of the LLC would not automatically subject you to the lien.
Even if you own most of it,
I'm sorry.
even if you own most of the business.
Again, that may be, again, if you're a passive investor and you're just a member of the LLC, not actively engaged in the running of the business, you would not be subject to the lien. The goal is to spur investment in our hospitality industry.
So if you've got 15 McDonald's on, then it would be the local person who is having to do everything that they told him to do for McDonald's, who would be responsible for not having gotten the check out in time.
I'm not sure I understand your question.
Well, I thought
If I can interject, Representative, we have someone from DRA, maybe. we can
yes,
let
I
that
know, I wanted to ask them too, but I thought I'd give the sponsor a chance to.
Representative Plett, then
I'm reading the bill, which is, I know, a not very smart thing to do. And it doesn't match with what you said the intent of the bill was, because I don't see anywhere in there, maybe you can point it out, refers to a passive investor. It just says that a lien shall be applied, and it will be include any person. It could be somewhere in there about with a manager or managerial capacity, president, treasurer, another person or managerial capacity. So a lien could be applied to the people running the business, but I don't see anything about a passive investor in there. Explain, please.
So again, that's it used to say in so again on line 11 of the bill, that the two words that are struck out there includes members and. Those members who are not active in the managerial capacity of the LLC are the passive investors, and we're taking those members out and just talking about the persons in the managerial capacity of an LLC. Does that answer your question?
Maybe. It would be clearer. It said it explicitly stated if someone's a passive investor, they're not included.
So in an LLC, you have members, right? Versus a S corp or a C corp, we all have equity owners, and so an LLC, everybody's a member, although you have managerial members as well. And so the point is, if you're just a passive member of an LLC because you provided an equity, you provided some revenue for the purpose of opening the restaurant, doesn't make you subject to it. Just being a member in and of itself.
Representative Ellery, followed by Fellows.
Senator, so your contention is that by striking the word member, you're eliminating all of the, by definition under the LLC law, passive individuals. And then by putting the word managerial in there, which is an undefined term under LLC, who are the managers? Because the director doesn't necessarily need to be a member. And yet the director is the one doing the day-to-day stuff. So should we add director and other managerial members?
So I'll just remind you, this isn't new law. This is existing law. What I've done is I've struck the word member and the word other. 3 words, right? So that it makes it clear that liens are applied to, again, under current law, any person in a managerial capacity of a limited liability company. So that's current law. I'm not adding that to statute. What I'm doing is I'm striking the members and making it clear it's the managerial members of an LLC that are responsible.
Follow up?
Follow up?
Who's a managerial member if it's not defined in either the LLC law or this law?
DRA is coming up. I'm sure you can, again, this is law that they already have. This isn't new definition. A person in a managerial capacity of a limited liability company is current law. I'm not adding that. So they've already made that determination, already do make that determination in some way, shape, or form under current law.
Thank you.
Okay, let me get there's a lot of questions. Let me get the order straight here. I think Fellows is next. Yes,
you.
Representative
So,
Fellows.
so if I wanted to know who are these people, so there's an LLC out there, a restaurant LLC, and would I know who are the members and the person in a managerial capacity? And also, this is a lien on property. The LLC might not own any property. The wife of one of the members might own the property. So how do you address that?
So again, that's a true statement. Again, this is not new law. Only thing we're doing in this law is removing the word members, which are the passive investors not actively engaged in the management of the LLC. That's the only thing this is doing. The law currently exists. So DRA is already making these determinations and already applying liens to the two people. The only difference is we don't want them to apply liens to passive investors who are not active in how the business is run or anything else. They provided an upfront bunch of money so they can open up a restaurant, and then the restaurant goes sideways. And it's up to DRA to determine who's responsible for that and to make sure the liens go to those persons. Again, there's already under current law or under current process, under equity investors for the purposes of a corporation, they make the same determination. If there's an asset transfer in a corporation of assets of the corporation to a equity owner, that automatically makes the equitable owner subject to a lien. So DRA is making these determinations already.
Okay. I don't know who was first, Southworth or Leapley, but Representative Leapley.
Thank you, Mr. Chair. I have two questions. Thanks for taking my question, Senator Lang. I have two questions. The first one is, what problem is this solving?
So again, in cases of, we have passive investors who had no actual idea of running the business. They just gave some money to an LLC and said, run the business. In 5 years, I'll see you and I'll get my profit back. And in the meantime, that business didn't pay their rooms and meals tax. And now that private investor has nothing to do with how the business is running. They just gave them money, is getting their private property attached for the liability that the restaurant owns.
Thank you. My second question is, my understanding of a member in an LLC is someone who can receive profit from an LLC. And it seems to me that it doesn't matter very much if you're involved in managing the company or not, if you're responsible for not having paid those taxes, but you should have a lien placed on your property if you receive profit or are in line to receive profit from a business. So to me, it seems like the bill is appropriate as it's laid out.
So again, I think that goes back into the phrase of transfer of assets. So if the money is transferred to you, then they could apply a lien to you. But if you haven't received any money and you're not part of that operation of the event, again, there's times where a restaurant will receive, and there are people here from the hospitality industry probably speak a way more better than this than I can. But my understanding is there are passive investors who put money into the thing, have no operational controls over the business other than they put investment money in. And the idea is they should not be subject to a private lien.
But going back to what Member Plett said, what the bill says is includes members and you're striking members.
Correct. So it's only managerial or people have had assets transferred to them.
So the bill that you're asking us to pass would make it so we can't put a lien on anyone on the people who are in line to receive profits from a company who didn't pay their taxes, that we should wait until the profit is transferred to that member, and then we could put a lien on their property.
So I just say that's exactly what happens in a corporation. Right. Again, in a corporational aspect of it, my understanding, DRA, I'm sure will correct me if I'm wrong, but we only go after the officers or where there's been an asset transfer.
So you think that's the correct way of doing things? And so the improvement to the law would be to correct how we handle LLCs and not correct how we handle corporations?
I think we handle corporations appropriately, again, to encourage investment into the hospitality industry in New Hampshire.
Thank you.
Senator Lang, I have a question. So as the bill if if a lien was placed because of a manager's failure to pay, that's only on the property of the business, not on the personal property.
It's personal property.
Could be
That's
on
the
the
whole
personal-
point of this, is that it's
Okay.
it's your home is being attached.
Okay, and you're saying this has always been this way, and all you're doing is removing the idea that a member who might be a passive investor would have their home.
Could not have their home
Right.
attached. Correct.
Okay, thank you. Now down here, Representative Southworth.
I'll ask the DRA as well. Thanks for taking my question. So the goal initially is to collect the taxes for the state and so forth, the original law. Won't this change make it harder for the state to collect the taxes that are due?
Again, if I guess the answer is yeah, sort of. It could. The idea again being is the person responsible should be the person who has the lien placed on them, right? So as a passive investor, you may have no responsibility at all in the LLC, and yet now you're being subject to it just because you loaned your friend some money to start a restaurant, and now your personal house is going to be attached because your friend screwed it up.
Understand that, but again, just to reiterate, it's going to make it harder for the state to become whole and collect its taxes.
I would just think it takes more due diligence that they'd have to make sure that they're attaching the lien to the right person.
Yeah.
And they'd still get it back because it's not stopping them from doing
And
a
I'll
lien.
ask them that question
Yeah.
too. I think they are probably diligent, but I'll ask them. Thank you.
I mean, the other I will just throw this out. Another possibility might be that passive members could be excluded as opposed to members, because some members can be active members. So
Again,
would you-
I
would
probably
you-
asked DRA that. I don't know that there's a delineation in law of
Okay.
passive versus
All
active
right.
members. I don't think there's a delineation. That's why we struck
Okay.
members and just said managerial is responsible. The people who manage the LLC is responsible, and their private property could be attached.
Okay.
The person who's not actively managing the LLC should not be attached.
Representative Ors.
Thank you, Mr. Chair, and thanks for taking my question. I'm sure DRA can answer this if you can't, but it sounds to me like this bill goes hand in hand with current law, Sarbanes-Oxley, where those that are responsible cannot claim ignorance and therefore they're held accountable.
Correct. So that's the whole goal. If you're a management and you're responsible for it, you should do it. But if you're someone over here who's not actively engaged, don't even know, they wouldn't even know that the rooms and meals tax weren't paid until all of a sudden they're getting a lien attached to their house.
Absolutely brilliant.
I will say this passed out of the Senate 4-1 bipartisan and out of my committee, and then it was a voice vote on the Senate floor.
Representative Almy, or no, Representative Almy.
Thank you. Would you object if we amended this to require the Secretary of State's office, I guess it is, to include the information about who is passive and who is not in the annual report that the businesses are supposed to make, which I hope they are making because they didn't used to.
Having not thought about that before this moment, I'd be hesitant to make a definitive statement. But again, I think that DRA is easily able to make that assessment again, because they already have in law the idea of who the managerial person is for an LLC. It's in current law.
Representative Fellows.
Thank you. If somebody was asked to invest in an LLC, become a member of the LLC, and if they were concerned about their property, being liable to seizure if the new LLC didn't make any money, wouldn't they have the option to just loan money to the LLC and at a certain interest rate? So aren't they kind of like getting in this? They should know what they're getting into, right?
There are multiple ways, to invest that way that you're talking about, whether it's a direct loan or whether it's a part of an LLC. So the answer to your question, I guess, is yes, you can do it either way. And I would expect that if you were that concerned, you would become an active member in the LLC and be involved in the management of it if you were that concerned about getting your money back.
Representative Ors, followed by Leapley.
Thank you, Mr. Chair. Thanks for taking my question. So follow up to Representative Omni as far as identifying the players. Wouldn't that be easily done within annual audits of the?
I would expect so. Again, that's probably a DRA question rather than me. I know that when I had my LLC, I had to file paperwork and my name was all over it. So obviously I would be subject to a lien if I was in the hospitality industry. But so again, I don't think it's necessarily hard to find.
So follow up.
Follow up.
So businesses are going to do an annual audit, I would assume, correct? They have to.
I don't know that the annual audit's public though. So again, because we're talking about
good
private
point.
LLCs, right? So I
Right.
don't know that an audit would be public like that, but your filings with the state are public.
But
So
if
when the
there's a-
LLC has to file its paperwork for BET, BPT, that's all public documentation,
Right.
public.
These are good
follow up.
questions for DRA.
Yeah, so-
I think we should move
Yeah,
on from
okay. Yep, very good. Thank you.
Representative Leapley.
Thank you for taking my question. Again, I'm just confused by the terms of active and passive. Are these when an LLC fills out paperwork to form itself with the state? Are those terms used?
Again, I already answered that question for the chairman. Those aren't. That's why I'd be worried about putting them into laws because we don't have it. And that's why I don't use the word active and passive. I struck the word members, making sure that the liens are only applied to managerial persons of the LLC.
I guess what I'm getting at is I'm not sure how law is concerned with defining things and that we're all talking about the same thing. And it seems like in this bill, we're striking member and your claim is that it's a passive member, but I don't understand how the DRA would understand which members were active and passive unless it's defined somewhere in writing.
So again, that's
That's-
current law. I just keep saying that. It's on line 11. The law already says, for the purpose of this section, operator in the case of corporations includes the president, treasurer, da 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 da. Operators in the case of a limited liability company includes any person in managerial capacity of the limited liability company. That's what the new law would read. And that's already current law. We just struck 3 words from current law. The words members and other. That's what this bill does, is strike those 3 words and leaves the rest of the existing law to make it so that it's the person in a managerial capacity of the limited liability company, which DRA must be able to know because it's current law.
So the
Okay.
question, follow up,
Is
thank
this,
you.
I mean, again,
So
is
just
this a DRA
follow question is your intention, I'm trying to true the presentation with the rules, with the words that are used in the bill, because current law says members and I know what a member is because that's defined. And when we fill out paperwork as an LLC, it says members. So I understand what a member is. So to strike that, it sounds a little bit like people who stand to make profit are protected from being liable for a tax bill that is due, and that those people aren't responsible. The only people who should be held responsible are the people who failed to pay the tax bill. Am I understanding that's your intention with this bill?
Intention on private lien is to say that it includes any person in a managerial capacity of the LLC. They're liable for the lien. That is my intent.
Okay, so it doesn't matter who is making profit from the business.
It's my intent to make the people responsible who pay the bill that run the business to be responsible for the lien and be held for the lien because it didn't get paid.
Okay. I just am confused because we have a thing called a business profits tax where we tax profits. So
All right.
thank you.
Okay. Thank you, Senator. Next, I've got Henry Veyu.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Henry Veyu, and I'm here on behalf of the New Hampshire Lodging and Restaurant Association. The association is the one that asked Senator Lang to put the bill in. And what I thought was pretty simple, I think has raised a lot of questions, you can see here. But here's the instance that we are trying to address. And this is really going to impact the small operators. So an instance where John wants to start a restaurant. John asks his parents for some money to help open the restaurant. John is obviously the one in the managerial capacity. It's his restaurant. John doesn't pay the rooms and meals tax. Under today's scenario with this, DRA can go after John's assets and the parents' assets, even though the parents aren't really involved in the day-to-day operation, which is different from a corporation. Because under the statute today, it says, for the purposes of this section, operator, which is going to be the entity that's going to be responsible for the tax, operator in the case of a corporation includes the president, treasurer, and any other person in a managerial capacity of said corporation. So that's what's in the current law. And then it says operator in the case of a limited liability company includes members, which the parents would be, and any other person in a managerial capacity of the limited liability company. So we're just trying to put the corporation and an LLC on the same footing with regards to potential tax lien for unpaid taxes. You can ask a lot of these questions. I think you should ask the department in terms of how do they figure out who's in a managerial capacity. I think they are best to answer that. I don't think this occurs a lot. And when we're talking about LLCs, we're talking about smaller operations. I think any unpaid taxes from a corporation potentially could far exceed what would potentially occur in an LLC. So that's the instance that this is trying to address. And
Thank you. Representative Almy.
The difference between corporations, other difference between the corporations and LLCs is that I've known people that have set up, one of them 25 LLCs, and I know that people set up one LLC for the parking garage and another LLC for the lot and another LLC for the restaurant and another for the hotel, so that they'd protect one from the other when someone was suing. And doesn't that apply in this case also, that you could have an LLC that for a restaurant that had subdivided all the other functions of it, and you couldn't put a lien on anything except the restaurant itself, which may be losing money?
I'm not sure I understand the question. Okay.
The question is, couldn't that occur?
Where, again?
If somebody set up a restaurant, but on the parking lot for that restaurant was in a separate LLC, and a third part of it, the food provision was another LLC, and so forth, that when you put a lien on it, the only thing you could put it on was the central restaurant rather than all the other parts of what is one business.
Again, what we're trying to address is an investor, the guy wants to start a restaurant. He can't get the total loan from the bank. They want someone else to take the risk. The parent puts some money in there, and this is just to try to protect that type of investor.
Representative Ellery.
Thank you. Thank you for taking my question. we're talking about LLCs only in this particular instance.
Yes.
304C23 already exempts members and managers or directors from liability, all liability, any debt, any source.
So that is
It's
the
what it
case,
says in law.
except when it comes to the rooms and meals tax. So I get what you're saying. We had one of the premier tax attorneys at the Sheehan Finney law firm who practiced this stuff. And he says, yes, exactly what you're saying is true. Most people, when they think they're investing in an LLC, that they are immune, that they are in the same situation you're talking, except when it comes to the rooms and meals tax. And you might want to ask the department that too. So it is true, except for the rooms and meals tax.
Follow up? Okay, yeah, that's a question. I see them writing them back, so I don't quite understand that. However, what's your definition of a manager? I see Dunkin' Donuts out there offering shift managers positions. All of the chains offer them, but it's not defined anywhere.
So I think the intent, and again, the department can probably respond because its current law is someone in a managerial position of managing the company.
Representative Ames.
Yeah, I just wanted to say that I really think we need DRA up.
Yep.
We're going around in circles, and we're not talking
I agree.
to the entity that's really responsible for this, that has the history of interpretation of this phrase and so
Yeah.
forth.
I agree. Thank you for your testimony.
All right, thank you.
And now we'll invite up DRA. I've got a card for Keen Meng Wong and then another card that says Department of Revenue. So whoever from the department wants to come up, come on up. And introduce yourselves when you're settled.
I'll start. Good morning, committee members. My name is Aura Lemire. I'm the Assistant Commissioner of the Department of Revenue Administration.
Could you
And-
your name?
Oh, I'm sorry, ORA. Last name is Lemire, Lemere, Assistant Commissioner. I was formerly the Collections Director for 6 years, so I've decided to accompany our Team Main Wong, Tax Policy Council.
Good afternoon, members of the committee. My name is Keen Ming Wong, Tax Policy Counsel with the New Hampshire Department of Revenue. The department does not have a position on this bill. However, the department does have concerns about the impact on the passage of this bill, specifically as what has been discussed today is in terms of the collectability of taxes that's owed to the state. Essentially, I just wanted to back up and probably just remind committee members that the M&R tax is a tax that's essentially levied on the customers. It's not a tax that is levied on the M&R operators. It's not a tax that's levied on the restaurants or the hotels. It's a tax that's paid by the customers, and it is collected upon the customers paying the bill. So when you go to a restaurant, you pay your bill after the meal. That tax is collected at that point by the operators, and that tax is collected on behalf of the state. So it does not belong to the operators. And the following month, on the 15th of the following month, that tax is then required by law to be remitted by the operators to the state, essentially to the DRA. And so as it happens, potentially people who operators who have this money in hand, for whatever reason, does not remit this tax that has already been collected that belongs to the state on the 15th of the following month, then the DRA and then if they do report that okay they have collected this amount of tax and they have remitted only X amount of tax, there's a shortfall, then the DRA would start the process in terms of trying to collect the outstanding taxes. There's also the audit process that's involved, and let's say if there are operators who report only a certain amount and pay that certain amount. But then when there's an audit process that involves, and then the DRA finds out that there's additional taxes that's owed, and then that's another process. However, with the lien process that's based on this bill here, essentially this lien is a lien on the operators, well, on the assets of the operator, the property of the operators. It's this section of the bill. Once if you read that carefully, it's not a lien on the assets of the LLC or the corporation. It's a lien on the assets of the operators. And then the DRA does go through a lengthy process before any lien is issued or attached to any kind of property. The collections division would make phone calls to the operators. The collections division would make field visits to the operators, asking them, just to follow up on the payments. Letters would be issued out to the operators to remind them to pay. And then the final, I guess the last alternative would be if the operators has not been responsive in terms of trying to work with the DRA to come up with a payment plan or trying to have any kind of showing any initiative to trying to settle the outstanding amounts, then and only then would a lien be taken, would be registered.
I will just add, excuse me, that with the collections process, again, Keen mentioned all of the tools in our toolkit, but there is also a level of judgment that's applied, that we do look toward the active members, if you will. And I know the statute does not clarify, and I'll kind of preempt the question. The Secretary of State's office does not define who is active and passive, but we do, in contact with that restaurant over months or any type of period, we do tend to know who is managing that company. And if it's a storefront manager who handles that daily cash, that's responsible for the deposit to the bank, that's obviously where we would start. We do discuss the terms with any of the LLC members, active or not. We explain the process to them. It is written on our application and defined in all of our forms that they would be personally responsible. When it does come to the time where we need to collect, we will make an attempt every time to work it out from the bottom up. I mean, we want to obviously contact the right person. And that includes negotiating. I understand that a parent may be involved on behalf of his or her son, but they also are an LLC member and do have an opportunity to get involved in that business and to know the actions of their son. But we would start with the son.
Representative Spilsbury.
Thank you, Mr. Chair. So I'm looking for an analogy, and I think the distinction that you pointed out is just so essential. The meals and rentals tax is a tax on the customer. So the restaurateur or operator is in a custodial relationship vis-a-vis the DRA. Right? This is essentially the same relationship as applies where you have an income tax, a personal income tax and withholding. No, we don't have that in New Hampshire, so it's not so much in our wheelhouse locally. But when a similar situation occurs with the IRS and a business has withheld the employee's portion of their payroll taxes, what exactly is the situation there when it comes to C corporations for guidance here? And I think part of what's going on in the statute is the statute doesn't clearly define operator. It includes a sentence that says in the case of a C corporation ... and it includes a sentence that says in the case of an LLC ... But as our the prior speaker indicated, the whole essence of corporations is limited liability. So the question, as Representative Ullery suggested, is you would start with the presumption that you can't pierce the corporate veil and assign liability to investors whose only interest is monetary. So what does the IRS do in exactly this situation when payroll taxes are not remitted?
That's a very good question. I've never looked into that, how the IRS would address this. But I think what I can say is that this statute has been around since 1995. And that is 93 was when New Hampshire first adopted the LLC statute. And then in 95, it's when in the M&R statutes that they looked, okay, there's this new organization that New Hampshire is recognizing. So then this additional language is placed into the lien statute in addition to what was already there for corporations.
Good history. I appreciate that context.
Representative Plitt?
Yes, I'm trying to understand the impact of this bill. And I heard Assistant Commissioner Lemire state that when it does get to the point of liens, after having tried every other aspect, that a level of judgment is applied. So you're going after despite the law covering everybody, that you would apply it to the sensitive managers, the people responsible for running the business. So what impact does this bill have on your collectability?
Well, there is some impact. Thank you for the question. But just to give you a big picture, there have been, since the beginning of the fiscal year, about 2,600 collections cases created, cases that flow down through an assessment to collections. Of that amount, between July and now, less than 5% are meals and rentals liens that have been placed. Out of that pool, 5% or less are meals and rentals, and an even lower percentage of those liens that have been placed on meals and rentals operators are applied as LLC operators, or to LLC members, if you will. So it's a very small pool, but it is a tool that we have available to us. Again, we've tried everything to collect debt: phone calls, repeated phone calls, field visits, payment plan options. When we do get to the point of placing a lien with a trustee's tax especially, we do look to those responsible parties, as we call them.
I also just want to add that I believe that our collections efforts are only as good as the information that we are able to get from the operators. The information that we get from an LLC operator, we cross-check that with the information that we're able to get from the Secretary of State. And the information that is available from the Secretary of State for the annual return filings of the LLC is at most probably just listing of one manager or one member. And then when the operators apply for a M&R license, we do require that the operator or the business lists down all the members and all the people with manager capacity with the form. So we can only do so much, but we're relying on the information that we have. And then when the operators are not responsive in terms of trying to work with us for collecting a tax that they have already collected and should be remitted to the state just the following month, and after we've gone through all the process in terms of trying to collect this money and contacting these operators, I think the final the final route would be to issue a lien, and then but to whom the liens would go to, then we would just rely on that information that we have. We can't, I think Representative Almy just now presented a very good suggestion in terms of should we require the Secretary of State to require that all LLCs to register when they register with the state, or when they file their annual returns, to list all members with manager capacity. That might be helpful because when we contact the operators, they may not be providing us with all that information so that we can specifically identify which specific member has the manager capacity. And we don't want to lose out in terms of collecting the money from the state, because there's the money that they've already took from the customers.
Thank you. Representative Southworth.
Thank you for taking my question. Just want to get the numbers correct. So, the scope of this is about 5% or less of the people that need collections follow-up. So it's not of all the businesses, it's just that smaller group that need collections follow-up. And then it's, less than 5%, you get to the lien level.
Right. The entire group that I was referring to
Yeah.
is the collections.
So it's a very small
activity.
part of the
Very
entire
small,
state.
yes, portion that actually gets a lien placed
And
in Meals and
follow-up?
Rentals lien.
Follow-up.
And I assume part of it, you mentioned it briefly, you do have options to offer them along the way.
Oh, definitely.
So it really is what do I want to say? It's really the final alternative.
Right.
Okay, that's helpful. Thank you.
Now Representative Ullery.
Thank you, Mr. Chair. Thank you for taking my questions. The remission, failure to make that remission, is that a civil or criminal activity?
It could be a criminal activity. I would presume it's statutorily required that Meals and Rentals operators remit that tax monthly.
Okay, follow-up. If it's either one, but especially if it's criminal, there has to be an individual who willfully undertook an action. An individual who willfully undertook an action, not the LLC, but an individual who, knowing that money belonged to the state and whose responsibility it was to transmit it, was a sole individual, not the LLC, not any member, which is why 30423 C23 takes place, to isolate them from an individual who was essentially stealing from the state. It would be no different than if that individual was taking from the till.
Do you want?
What's your question, Representative?
Is that correct?
Okay.
Yeah. So we're not prosecuting attorneys, so it's just very difficult for us to answer that question. But I just want to go back to the point that that was also mentioned during this hearing before, that the LLCs, they have members, and members have access to the profits from the LLCs. So essentially, I'm trying to imagine that this activity of lien, we're not liening anything more than what the tax is owed or the interest or the penalty, and essentially, this is, I would akin this to an action of trying to disgorge the profits that's unrightfully kept by the members or whomever, because they have access to the profits of the LLC, and therefore returning that money back to the state.
Thank you for the question, Representative Ullery. It's actually a great point. I will point out that in recent years, when I was the collections director, that there is not very often just a sole individual involved. That there could be a manager, again, who's taking those deposits daily to the bank, who reports those to, a corporation, or as Representative Almy pointed out, it could be a string of LLCs that, are funneling that money. We did have some recent court cases where there were a number of individuals that were determined to be held liable in an LLC situation, and I don't have the references in front of me, but I could get that information for you.
Mr. Chair?
Follow-up?
Yeah, I would. Yes, I would appreciate that information, and I would appreciate the Cheney and Fian comment as well. The question then, from your testimony thus far, revolves back to an undefined term as to what a manager is or what management is, because it doesn't exist either in the tax section or in the LLC section. There ain't no such credit. And in addition to that, I'd like to know, on the contract that you sign for the remittance, if that does not put the individual signing the contract personally liable for the remission of the funds.
It does.
It doesn't?
It does.
It does. Well, There's your guy.
On the, I'll just clarify, on our application, it's a CD3 form, you can get it online. There are a number of boxes. We look for the person who's managing the company, LLC. It could be, a relative, or it could be someone that's hired. We do look for the manager as well, as we include, and the statute's clear that it includes members and anyone in a manager capacity. It's not limited to the one person.
There's no manager in an LLC.
Well, there is a manager. There can be a member managed or a manager managed LLC. There can also be no managers, member managers, but there are passive investors who put a manager at a storefront to do the daily operations. We look for that person who's on location, as well as LLC members who are behind the scenes collecting those profits.
Representative Ames.
Do you think it would help to further define managerial capacity in this statute? And if so, do you have suggestions?
Thank you, sir.
I think that would be helpful, but I think the core of DRA's concern is just trying to identify those people in the manager capacity, and then because right now, as it currently stands, we rely on information from the Secretary of State, and then information that's been filed with the DRA, and it may not be as complete as we would like in terms of trying to when it comes to trying to administer the collections of the taxes.
I have a question, and I'll come back to you. So as it stands now, the current law, let's say you have an LLC, there's 5 members. They're not paying the M&R tax. Do you put 1/5 lien on each of them, or how does that work?
The lien gets placed in full on each member. And
okay.
the LLC first, the entity first, and the amount of the lien that's filed is against each member and the entity.
Okay, thank you.
We will work out, obviously, with, payment
Right.
arrangements, and we will determine, sometimes there are K1s that we refer to see who holds what interests, but we typically would expect them to, as members, work that out between them.
Right, thank you. Representative Ames.
Yeah, I just ask that you consider the question I asked and whether there is some remedy to this apparent problem of putting all the weight on the managerial capacity concept that now is the core concept for an LLB in terms of your placing a lien, and whether a better definition of that is going to move us to a better place, or additional requirement for filing with you or with the Secretary of State might be helpful. I think if you could think about this and get back to us, that might be helpful.
I have another meeting.
Okay, thank you.
Be a part of this.
Representative Fellows.
Thank you. My concern is the concept of manager, because in most restaurant, if you say the restaurant down the road, who's the manager of that? People think of it as being the person at the top of the totem pole of the employees, or it could be the owner, but they're in that restaurant essentially most of the time. And that if somebody in the restaurant is diverting those payments, I don't know, somehow saying they're taking them and depositing them in the bank, but they're not, they're putting it in their pocket. That could be the manager, it could be a lower employee, and that is theft, and they should be prosecuted for that. But in terms of the business, which is owned by the partners collectively, that's my way to make a distinction here, then they're the owners of the business and they're the ones that are responsible for what the manager does and all the other employees. I mean, you don't know, maybe the owners, maybe they have somebody in the members that tells the manager, okay, we want you to give us the cash and that comes in every day. Well, I mean, it's not, now it's mostly credit cards, but anyway, suppose it was all cash and that we're going to take care of paying the bills. You know, they've got an accountant, somebody else is paying the light bills
there a
and
question
and
there,
that. So my
Representative?
question is, I am concerned that, do you have that concerns about identifying somebody as the manager? It seems to me that it doesn't even belong in here.
I thank you for the question, Representative. I think it's important that you acknowledge that there could be two types of managers, right? There's a manager at the location. You're sitting at a restaurant having dinner. You ask to speak to the manager. You're going to get a person. And typically that person is responsible for the day-to-day deposits. If there was some failure to remit those to the bank at that point, then yes, that person would be responsible. But however, what if that manager does deposit daily and it's the person in control, the manager that's in control of the bank account, or the, you know, member that's in control of the bank account that doesn't pay the tax? So we do recognize both. We do ask for information upon the application, the CD3, for any members, especially the manager who's at the location. Again, that would be the first contact. And the enforcement that we did take would start at that level.
Representative Spilsbury.
Yes, thank you, Mr. Chairman. This isn't so much a question of our witnesses, but it is in part. I think we've come to a point where it's getting kind of circular. This is ripe for a very meaty work session. And to be prepared for that work session, now back to our witnesses, it would be extremely helpful to have, as Representative Ames suggested, any suggestions that you might have regarding definitions. So particularly the definition of an operator and the definition of a manager or managerial capacity in this context. But also, I think we need to know, what does the IRS do in that analogous situation where effectively taxes are withheld from employees and there's a trust relationship that's created, there's criminal liability and all of the ramifications that go along with that in federal tax practice regarding corporate entities? Because I do think that what we're seeing here unmasked is a lot of ambiguity in our existing law about different forms of business ownership and arrangement, and how that relates to the corporate limited liability and how that relates to tax liability. And I think this statute is essentially making an exception or going beyond the normal understandings of limited liability. And that's the frustration of our prior witness. So I think what the bill is trying to address is fairly clear. Not making passive investors liable to have their homes attached. But I think that how we get there is going to take some careful work.
And the question was, can you bring that data?
Can you
to
help us be prepared for our work session?
Okay. Thank you. Representative Leapley.
Thank you, Chair, for taking my question. I think the other side of, we've had a couple questions around that side of the information. I think the other side that we need to make sure we have information about is, if we narrow this legislatively, does it make the DRA's job harder? And I think if they could clarify for us, I'm thinking, for example, I'm not sure if this is true, but I wonder if those members aren't listed legislatively. They're not listed in the law. Does that impact their ability to negotiate with the owners, right? The members, making sure that pressure is put on to get the answers that are needed. So I want to make sure, I'm not convinced yet that this is an improvement to the statute. So I want to make sure that we have all the information from the DRA that's going to reveal how, if we narrow this legislatively, it might make their job harder.
Thank you. One thing I was wondering is, when I look at corporations, in the statute here, it talked about how, I don't know where it is exactly now, but about the president or president, treasurer, or other person in a managerial capacity. So if you're a stockholder in a corporation, this wouldn't apply to you. If it's an incorporated entity, then it's only the managers and the officers. Is that correct?
I think that's a very good question, Representative. So just looking at the wording of the statute, it says for purposes of this section, operate in the case of a corporation includes the president, treasurer, and any other persons in manager capacity. And then when it's an LLC, it includes members and any other persons in manager capacity. So the term just says includes, it doesn't exclude. So I think
Based on the interpretation, he's trying to say that it doesn't exclude shareholders.
right.
It doesn't exclude the shareholders. It would include anybody in any sort of responsibility type position.
I see what you're
in a
saying. The
share-
word includes, yeah.
The
Right.
word is includes.
Okay.
But I think we also need to just bear in mind that that the definition operator is defined up further top in the statute in the definition section. Who is an operator? Operator is a person who it's just the word operates or manages the facility itself, either the hotel or the restaurant. So there is a definition for operators up top in the definition section.
Thank you. We will definitely be having a work session on this, but we'll take a couple more questions. Representative Fellows.
Oh, no, it's not for a question for them.
Oh.
I'm just wondering if we should, for the work session, get somebody from the Secretary of State's office, because that's where they file the LLC application, because it seems to me we're talking about possibly identifying people and that are responsible for the LLC, and that would be the place I would think that it would show up.
Representative Schamberg.
Thank you, Mr. Chairman. Two questions. Reading the methodology here, talks of the definition of operator and a managerial. Do operators or managerial people have to show that they have real property to be able to file a lien on when they fill out their applications?
They do not.
They do not. Second question. You talk about payments. You're going to have to update all necessary tax returns and forms and electronic management systems. Is there any way that you can do it like Irving Debit Pay? When you put your card in, they take it right out of your checking account. So when they deposit their money, within the next 12 hours, it's coming back to the state? Just take it under, roll it around upstairs. Thank you.
All right. I would say my personal opinion of that is the answer is no, because they're taking it from the customer's credit card or the customer's debit card.
Yeah.
Mr. Chairman, I meant at the end of the day, they got to deposit it. It's coming back out of the.
Representative Almy.
Thank you. I had 3 questions that I started with and still haven't asked. Are franchises sometimes LLCs?
Yes.
Yeah.
So in that case, the principal manager, because they insist on exactly what is done, could be somebody in DC or somewhere on.
Yes, you're right.
So that's a complication. And LLCs are based, the whole idea was to avoid liability for one business against another business. So what do you do with somebody who has structured his restaurant so that the parking lot is separate from the kitchen, is separate from the dining room?
Go ahead.
in terms of where the liens go.
I'm not familiar with this situation, but I think what we need to do is also go to who is the license who is the holder of the license. If the holder of the license is just the LLC that manages the restaurant, and that would be the operator of the
So
restaurant.
you'd think then that you could get into the lien on the parking lot and things like that if
I'm sorry, I'm going to jump in. And I think it's a good question because you're trying to show how that separation occurs so they are protected from the liability.
Right.
However, in meals and rentals tax operator's license, we are looking for the income and the revenue from the activity, which is the restaurant portion or the lodging portion. So we would only put a lien on the LLC that represented the entity that collected the revenues. Not the LLC or for the parking lot or another property.
even though they may have structured that so that
Exactly.
if they go bankrupt, you can't get
Right.
it.
So we're limited to the LLC that collects the
Right.
tax.
And then the third one was in the LLC law, if on the passive investors are not getting paid for the first 5 years, but you are not getting your transfer, you can't go after them ever for that period?
I think it's just the opposite that in this case we do. We don't look for with the trustees tax in M&R in this chapter in particular, there is no transfer necessary. We don't have to go through an audit process or a hearing to determine where those assets go. We would necessarily just place the lien regardless.
But you'd place the lien also on the passive investors, even though they aren't getting any money back,
Yes, yes.
even if this passes. I thought that was why this thing was written.
Well, I think the idea is to negotiate with the person who is responsible. And again, that's where we start. The lien is placed on the entity first, and that it goes through a series of steps before we determine to even place it on an individual or individuals. The LLC is responsible, and I think it's been mentioned that that's where the responsibility lies. However, if we are unsuccessful in our attempts to collect from the LLC itself, after placing liens as well, or realize that the LLC does not own any property in this state, because that is also a factor, then we would look to the responsible parties, beginning with the manager at the location and so on.
Thank you. Representative Doucette.
I should know this. Thank you for taking my question. I should know this off the top of my head. Do we collect M&R from Airbnbs and the like? We do. It just opens another interesting component here.
Agreed.
Okay. Are we complete? Any more questions of DRA? I guess not. Thank you very much for coming.
Thank you.
All right. I have no more pink cards for SB 585. So I'm assuming there's no one else that would like to testify. Seeing none, I will close the public hearing on SB 585. Okay, so that completes our business today. So the question I'm sure most of you have are, when are we meeting again? And so right now the status is we have just the three bills that we did the public hearings on today are the only bills left to do something with. And for now, crossover being Thursday, we may get more. But at this point, I see no point in meeting next week to do these three. Most likely, we should meet the following week, which would be what is Monday? Monday's the 18th. No, wait a minute. Monday's the 18th, isn't it?
Next one.
I mean next Monday. Let me look. Let's look at a calendar.
Next Monday's.
Next, So no, I just said we're not meeting next Monday, next week. So Monday's the 22nd and Tuesday the 23rd. I'm focusing more, I think at this point on Tuesday the 23rd, but I would ask that for now, you know, especially till the end of this week so we can see what's happening, hold Monday the 22nd and Tuesday the 23rd open with the idea that if we can get what we need to get done in one day, I'm going to do Tuesday the 23rd. So the odds of Monday the 22nd, I think, are low, but I want at least, you know, so probably, okay, probably the next meeting is Tuesday the 23rd.
Excuse me,
Bleakley.
Mr. Chair.
Yeah.
That's school vacation week. I don't know if it's absolutely necessary that we meet that week.
I know, I struggled with that because I think I actually sent an email like 2 months ago saying we would take that week off. But my concern now is that that would then push us into April 30th. And then we are just, no, April 30th is Tuesday. And then these bills have to be done by May 16th. So there is still time. I don't know. I don't want to commit right now to not doing Tuesday the 23rd.
Yeah.
Um,
Okay.
So, yeah, yes, Representative Flake.
Mr. Chair, I wonder if there's some advantage in meeting next week just to have the work sessions, because there might be amendment requests coming out of that, which may need time to prepare. And,
Well-
but just have the work sessions.
Well, I'm thinking that the 20, I don't know. Yeah, we have till May 16th. And I would have to put the request in today. If there was, the thing is Thursday, we might get more bills in and then I'll know we have public hearings as well. So I'd prefer not to meet next week. Any other questions? All right. Thank you. Thank you, everyone.